Please, your lordship. My lord, for unlisted motion, my lord, today, my lord, is a eviction matter, my lord. Notice issued on 18/12, served on my lord 19 and 20. Some of the petitioners, my lord, asked to vacate within 7 days, my lord.
Have you filed?
Yes, your lordship, filing serial number 15893.
Bring it before 2 o'clock, 1 o'clock.
My lord, my lord. Highly obliged.
I have a similar query also. Yesterday at 4 p.m. we have been intimated without there being any order also communicated to us. It's a stamp vendor within the campus of DC office Guwahati. They have been asked to be evicted also, but in terms of the license, they are to operate within the campus also.
No, I have filed.
Already filed also.
Okay.
Deeply obliged.
Your lordship, I beg for an accommodation in item number 15, your lordship.
15.
Yes, my lord. Can it kindly be taken up on 11th of January, my lord?
11, 14. 12.
Most of
On the prayer of Mr. S. Day, Learned Counsel for the petitioner, lays the case on 12/1. It is submitted at counsel has been taken for the Learned Counsel for the response to make up.
lordship. Most of it.
Please, your lordship. Lordship, in today's date is item number 18, lordship.
18.
18,
Yes.
lordship. Lordship, in this matter, we are newly engaged counsels and we have filed our Bakalatnama yesterday. That Bakalatnama is not on record. So I am praying if your lordship may kindly allow to call for the Bakalatnama.
Lordship, I pray for listing or repetition, my lord, on 3rd, if on the reopening, my lord, if possible, my lord. Matter relates to illegal construction, my lord.
Okay.
Obliged, my lord.
May I please, lordship, I beg to mention item number 21, lordship. The engaged counsel is not present, lordship. Lordship, kindly adjourn the matter fixed on 8 January.
Your MS
M. Deca.
M. Deca, Learned Counsel appearing for MS G. Bora. Learned Counsel for the petitioner submitted that MS Bora has some personal difficulty today and has thus paid for listing of the case on another date. So the Procedural leaves the case. Case is possible for the day.
Obliged, lordship.
Please, your lordship. Lordship, I'm praying for listing of a writ petition, your lord, a review petition, your lordship, on any date convenient, your lord.
File ODT.
Daily list for motion, item number 1.
Wait, please.
Yes.
In this case, my lord, the land of the petitioners, my lord, were acquisition, my lord, for upgradation and my lord, development of 1 PW road, my lord. Although my lord, substantial damage has been caused, my lord, no compensation has been paid, my lord. And they are proposing to damage other properties, my lord, by the respondents, despite my representation before the authority, my lord.
Where it is situated?
It is, my lord, Bhuyakhat under Kolaigaon Muja, my lord. Kolaigaon Revenue Circle. Under
For what construction is for what purpose?
It's a, my lord, Assam Mala, under Assam Mala, my lord, existing PW road has been, my lord, upgraded, my lord, and extended, my lord. Then at Bhuyakhat, my lord, where the petitioner's land is, my lord, situated, they developed the land, the road, my lord, by constructing a culvert, my lord. Page 22, a lordship will.
Your land is acquired?
My lord. And damage has been caused to my lord, the walls and other properties, my lord. But no assessment or my lord, compensation is.
Yes, MS Borua.
My only prayer, my lord, at this stage, my lord, unless and until my lord, assessment has been made and compensation is assessed, my lord, no further damage may be caused, my lord. This is my prayer.
Heard Mr. P.J. Soikia. Counsel for the petitioner. Able to say revenue 1 and 2. M. Das, standing counsel, PWD for the respondent number 3. 7. S. Purua, Junior Government Production for Correspondent number 456. S. R. Rava, 8. BTC, 8. Full stop. The petitioner has claimed that he is the recorded paternal of a plot of land measuring 1 biga 3 katha as 18 lessons covered by tag number 343, patta number 22, situated at village Miakat, Kolaya Moja, district Udalguri BTC, subject. The petitioner has contended that the respondent authorities are undertaking construction works for improvement and upgradation of an existing PWD route between Dolong Ghat and Tongla under the Ahom Mala scheme. And existing PWD road in front of the subject plot. Under it is a case of the petitioner that a part of the subject lot has been taken over by the respondent authorities for the purpose of the said construction of without undertaking any acquisition process. That too, without making any survey, prior survey to assess the damages caused to that part of the subject. Aggrieved thereby, the petitioner has preferred the instant litigation. Issue notice returnable on so and so as so and so appeared, accepted notice, no formal notice. Extra copies by today. By today. It is observed that having regard to the projections made by the petition, that no prior notice and no prior survey to assess the damages as regards the subject plot have been undertaken by the respondent authorities till date, the respondent authorities before undertaking any further work related to the construction shall make proper assessment of the damages caused to the part of the subject plot in the meantime.
I'm all right.
Item number 2.
Thank you, Your Lordship. My lord, here in this case, Lordship, petitioner before your Lordship, because they are not a related.
This is quasi.
My
lord, that is passing my
The DV case.
domestic
Lordship.
violence. Yes.
This case, this is regarding what?
Regarding Lordship, that the
What kind of relief?
My lord.
relief is that Lordship. Regarding the petitioners before your Lordship, they are not at all related with the
That is one issue.
One
Firstly,
issue.
this is criminal or civil proceeding?
Lordship. It is a quasi judicial civil proceeding, Lordship.
Huh?
It is a, as per latest judgment of the apex court, Lordship. It is a domestic violence is a civil quasi judicial lordship matter, which under 226 or 227 petition.
I think it should be 227,
Lordship.
not
I-
226.
My
lord, I'm.
No, lordship. But
If it is a civil proceeding, it should be 227.
lordship. Lordship, dog, it is a
Or if
quasi.
it is criminal proceeding, then it should be writ petition criminal.
Lordship, with all respect, Lordship, latest judgment of the Kamachi of the Apex Court says that 482 petition is not maintainable against the DB case,
Supreme Court.
Supreme Court.
Ah.
And Lordship, under Article 226, I can come as per the latest judgment as well as the other judgments also. I am relying one judgment, Lordship, though I have only one copy. Where may I read the line of that, Lordship? That it was observed when an accused comes before the High Court involving either the inherent powers under Section 482 CRPC or the extraordinary jurisdiction under Article 226 of the Constitution to get the FIR of the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous, vexatious, or instituted with an ulterior motive of wreaking vengeance. And in such circumstances, the High Court owes a duty to look into the FIR with a care and little court closely. It was further observed that it will not be enough for the court to look into the aberrations made in the FIR or comment alone for the ascertaining whether necessary.
No, Mr. Mazumdar, there is no doubt about that proposition.
Lordship.
226 and 482, there is no doubt about the
Lordship.
that proposition.
Kindly,
Right.
Lordship.
I want to know that whether this is a civil proceeding or criminal proceeding, an application under Section 12 of the DB Act.
Lordship.
If it is a criminal proceeding, there is no doubt either 482 or writ petition criminal,
Lordship.
not writ petition civil.
Civil.
If it is an FIR,
Lordship.
it is not an FIR.
Not an FIR.
It is an application under Section 12
12.
DB Act. Right.
Like
482 is not maintainable.
Lordship.
226 criminal is not maintainable.
Lordship.
Right.
Lordship. Correct.
Then when an application under 12 is to be, say, challenged,
Lordship.
whether it is 227,
That is.
that is what. Otherwise, my privacy view is it is 227. If it
Against
is civil nature,
Lordship.
if
It
the
is civil nature.
if the proceeding is of civil nature,
Civil nature.
then it would be 227.
Lordship, I also 226/227 with all.
No, then it will be.
Then the Lordship may consider under 227 also.
So that has to be changed. Nomenclature is to be changed.
But
This is-
my respect to submission.
Because WPC is WPC,
Lordship.
C means civil.
Civil.
Then it may not. Then it will be CRP.
But Lordship, my respect to submission. It is under, since I already challenged that portion of the Section 12 of the DB Act, under is a purely a civil dispute that is quasi judicial. What I can, with all respect, I'm submitting. And as per the various judgment, Lordship.
No, that judgment is regarding quashing of FIR, which
Lordship.
is not applicable in your case. That is plain and clear.
Lordship.
Right from Bhajan Lal.
Lordship.
There is no doubt about it.
Lordship.
For quashing of an FIR, it is 482 or writ petition criminal.
Lordship.
Because the subsequent stages are, suppose your writ petition is or writ petition criminal is dismissed
Lordship.
or allowed,
Lordship.
the aggrieved party cannot go to the division bench.
Lordship.
He has to approach the Honorable Supreme Court.
Lordship. In other law, correct, Lordship.
Right.
Correct.
So your case is, if it is DV case, is not criminal nature.
Lordship.
482 or writ petition criminal is not maintainable.
Lordship.
Now, if it is civil nature,
Lordship.
then I think it is 227 and it should be categorized as per Honorable Supreme Court's judgment,
Lordship.
categorized as CRP. That has to be looked into.
Lordship.
Otherwise,
will-
I'm not very convinced.
Lordship. With all
Not,
respect, Lordship, I am submitting. That point may kindly be kept open by.
that will not keep open.
And apart from that,
No,
Lordship,
that will not be kept open.
uh,
We will examine the very initiation itself, whether it should be CRP or WPC.
but in one.
Because jurisdiction is different,
Lordship,
both jurisdiction.
Lordship. But if it is Lordship, there is the one judgment of the Jammu and Kashmir Lordship.
Show me, there are so many Supreme Court judgments.
That is Supreme Court judgment, Kamachi.
Show me some.
Actually,
Because every,
Lordship.
some high courts exercises jurisdiction everywhere. Ultimately, it is settled by the Supreme Court.
Lordship.
So show me anything.
So after vacation, any other day, subject to convenience, Lordship.
Because I have some.
Lordship, nicely, that question, correct, Lordship, raising that whether that to be a criminal or civil. That point, I should have to clarify on that, Lordship. Actually, what has happened, Lordship, there is a date, they are in court, learned court below.
There is no harm.
And also, Lordship, one judgment of the Jammu and Kashmir, Lordship.
There is no harm in participating and
No, Lordship,
trying to extricate yourself out by
Lordship,
presenting the total facts. We'll examine that.
After vacation.
Meantime,
Lordship,
heard Mr. K. Mojumdar, learned counsel for the petitioners, and Mr. B. Sharma, learned public prosecutor for the respondent state. Those of learned counsel for the parties have submitted that they would address on the maintainability of a writ petition under Article 226 of the Constitution of India to challenge. And you have written in the cause title, second part, second head note, quashing,
Lordship.
setting aside of impure criminal proceeding. On one side, you are submitting it is civil.
It is a criminal
and-
proceeding, Lordship.
Huh?
It is DB case is that proceeding, Lordship. I am indicating the DB case proceeding, Lordship.
A DV case proceeding is civil or criminal?
They will have to clarify.
You are submitting civil.
Lordship.
Presenting the writ petition as criminal proceeding.
Lordship.
First, you
Minor,
make yourself sure.
Lordship.
Then you make submission. Then I'll find out whether
One judgment of the Jammu and Kashmir Lordship, very recent judgment, where may I supply the copy just for taking time.
okay, we'll keep it.
minor.
Lordship. Paragraph.
Has sought for some time to address on the maintainability,
Paragraph 13, may I kindly.
stroke, maintainability of a writ petition under Article 226 of the Constitution of India to assail a proceedings arising out of an application under Section 12 of the
Domestic violence.
Protection of whatever Domestic
No.
Violence Act,
Lordship.
2000,
Domestic violence case, Lordship.
because it is bit confusing,
Lordship, please.
because it is pending before CGM, Chief Judicial,
CGM, Lordship.
who exercise criminal jurisdiction.
Lordship.
And I have also found somewhere it
Minor.
is
In the domestic
quasi,
quashing, my lord.
quasi civil.
Minor,
Civil,
quasi-
criminal, both. Here in Jammu Kashmir Lordship, it was observed that the Supreme Court in Radhesham versus so-and-so has observed on Article 227 of the Constitution, orders of both civil and criminal can be examined only in a very so-and-so circumstances. There is no bar in entertaining a petition under Article 227.
No, there are other judgments where that don't mix up 226 and 227.
Lordship, correct, Lordship.
Don't mix up
Several
those
judgments are there.
jurisdictions, both are different,
Lordship,
and don't club both the articles and in filing a petition.
Lordship. If it is criminal, then the Lordship can
226 criminal side,
criminal side, Lordship.
because any order passed in that side, there is no letter pending appeal before the division.
Lordship, correct.
It will be before the order of
I
Supreme Court of India.
I accept that with all respect, Lord.
So assuming a jurisdiction which is not vested is also not correct,
Lordship, not correct, Lordship.
because I do not want to issue a notice where I do not have the jurisdiction.
minor.
Lordship,
Am I clear?
Lordship, correct.
Okay, list.
Lordship,
On 5-1 or 8-1? 5-1?
it may be on
5-1 or 8-1? as sought for by the learning council for the parties. This
Eight-
case on 8-1.
It may be 8-1, Lordship.
Obliged.
Item number 3.
May it please your lordship. My lords, one similar repetition is pending before this honorable High Court, your lordship. I will state in para number 16, your lordship.
16.
WBC number 7335 of 2023, your lordship. Notice already been issued, your lordship. Similar order is also there, your lordship. Order passed on 8.
You are that person in that repetition or different person?
I'm a different person, your
Okay,
lordship.
different.
I'm a different person, your lordship.
No, otherwise, there is no case, my lord. Advertisement explicitly clear down below para 3. Candidates applying for the post of peon must have passed class 8, but candidates who have passed class 12 and above shall not be eligible for the post. So there was express bar in the advertisement itself that only 8 pass will come, others will not come. It's not a case that minimum qualification is class 8 pass. That the position of the higher qualification will presuppose the minimum qualification. That is not the case here. Absolutely, he concealed this information while submitting application, and my lord, he got appointment and he was given show cause notice, and thereafter his case was terminated.
Heard Mr. A. Diwan, learned counsel for the petitioner. Mr. H.K. Das, learned standing counsel. ZHC for all the respondents.
1 and 3, my lord.
1 and 3 and MS S. Borua.
What 2?
Learned. Who is this?
Lordship.
Who is 2?
Commissioner,
Who is
nothing
2?
is there.
Nothing is there.
Commissioner,
Already been terminated. It is not a case of eviction. You have hurriedly filed this petition.
just for now, two commission secretary of the government.
This kind of things can be condoned in a case of eviction, but this is not correct. Nowadays, we cannot allow you to correct it by hand also.
Yes.
That is the difficulty. Read response number 2.
Response number 2, your lordship.
Read.
The state of Assam represented by the commission secretary. Government of Assam.
Which department?
Inadvertent mistake is there, lordship.
File your amended memo, then we will issue notice. Otherwise, you have been terminated already.
Lordship already terminated.
And there is no likelihood of staying the order.
Lordship,
Am I clear? Once terminated, it will be examined. If you have any interim prayer.
no, Lordship, I don't have an interim prayer, Lordship.
So,
Because I have challenged the Lordship.
correct, by filing amended memo. I think it will be judicial department.
Judicial.
Because your lordship, I have annex 1, page 33, your lordship. Because there is some inconsistency in the advertisement, your lordship.
No,
But,
that is a different thing.
so therefore, your lordship, since the government of Assam is the party, your lordship. So therefore, commission secretary has been made as party here, your lordship.
I'm not here you to,
Lordship, I'll correct
I'm
it
not
accordingly.
sitting here
Lordship, lordship.
as a law teacher.
Lordship.
On the prayer of Mr. A. Duval and a council board of petitioner, leaves the case on some other later detail. Mr. H.K. Das, learned standing also GHC for response number 1 and 3 is present.
I leave it.
Item number 24.
Council board of petitioner is at liberty to file amended cost title in terms of the notification dated so and so before the registry.
Item number 4.
File it on, next date is 8.
Fine.
Otherwise, holidays will be there.
Yes.
Obliged.
Item number 4.
Lordship, matter pertains to ex-gratia to be paid to the persons who died during COVID, Lordship, while performing COVID duties, Lordship.
This page 16 notification.
Notification page 18 is the gazette notification, Lordship.
Gazette notification.
Yes, subsequently gazette was published.
Oh,
As per gazette, Lordship, Deputy Commissioner was required to process, Lordship.
Petitioner's husband and father.
Father, who is the son?
Okay.
Mine.
He was,
Chief Medical and Health Officer, Lordship.
okay. Third, Mr. M.K. Hussain. Learned counsel for the petitioners. M.S. D. Bora. Learned standing counsel, Health and Family Welfare Department for the respondent number 1,
1, 2, 6,
6.
Yeah.
7 also?
11 and 12.
7?
No, it is mission director. NHM.
11.
Yes, 11
12.
and 12.
A. Bhattacharyji. Standing Councillor Revenue and Disaster Management Department for the respondent number 3 and 4. S. Borua.
8, 9, 10.
Learned Junior Government Advocate Assam for the respondent number 5 also. State level committee, some.
There is
There
Health
will-
Department, Lordship. Health,
Health Department.
Health, Lordship.
Then MS Bora, 5 also.
Yes, Lordship.
5, huh? So S. Borua will be
8, 9,
8, 9, 10. MS Bora, I think 13 also.
13, that will go by.
Why?
Nodal
FA Medical
officer.
College.
Yes.
FA Medical College. Why
Yes,
it
yes,
should
Lordship.
go?
13 also, Lordship.
Oh,
13 also.
Ako revise koribo. D Bora. 1, 2,
1, 2,
5,
5,
6,
6,
11,
11,
12,
12, and
13.
13. Yes.
A Bhattacharyji, 3, 4.
Or 7, B Gogoi names may be recorded.
S Borua, 8, 9, 10. Mr. B Gogoi, standing counsel
For
NHM for the respondent number
7.
7. The petitioner, the two petitioners are were the wife and son, were the wife and the son of one Dr. Hikmat Ali Ahmed, who was serving as the chief medical and health officer in the office of the respondent number 11 at the time of his death on 10/5/2021.
Lordship.
Full stop. The disease Hikmat Ali Ahmed. The disease died in harness due to COVID-19 contacted while performing his official duties in combating and in combating COVID-19 pandemic. Full stop. As by an office memorandum dated 8/10/2020, published in the Assam Gazette on 28/10/2020, Annexure B. The state government has formulated a policy to sanction ex-gratia grant of rupees 50 lakh to the next of kin as stroke legal heir of a doctor of the health department on duty. Full stop. As the petitioners, the petitioners have claimed that they are entitled to receive the ex-gratia grant in terms of the said office memorandum, and accordingly, an application was submitted before the respondent authorities. Application was duly submitted before the respondent authorities. Full stop. Though the said application is being processed at various levels, but the same, according to the petitioners, has not been given due consideration. Full stop. As a result, the matter of grant of ex-gratia has unnecessarily taken prolonged period of time. Hence the repetition. As so and so appeared, accepted. No formal notice, extra copies. By the day, within 2 working days, the respondents shall file their respective counter affidavits on or before the next date of it.
Lordship, in state of application, particulars were submitted, Lordship. There is no provision for application. Particulars were submitted.
Particulars.
There's no.
From the documents,
Lordship.
issue notice. From the documents annexed to the writ petition, it transpires that the matter of sanction of ex-gratia grant to the petitioners is being processed at various levels. Full stop. In such view of the matter, the respondent authorities shall file their counter affidavits on or before the next date of listing as regards the status of processing of the claim of the petitioner for ex-gratia.
Item number 5. May I please, your Lordship, my lord. In this case, my lord, petitioner claims for occupancy rights, my lord, under some temporary settled areas, tenancy act 1971.
Occupancy right.
Yes,
So
petitioner. My lord,
you have not got occupancy right.
No, my lord, till now.
Then in the records, whose names are appearing?
My lord, kindly see the annexure D, my lord, page 41. Letter from my lord, additional deputy commissioner to my lord, circle officer, certified revenue circle.
Then
Thereafter, my
what
lord,
why you are not?
my lord, 42, kindly see, my lord, page
I have
42.
seen for 39. 39 type copy,
Yes, my lord.
page 40.
40, yes, my lord.
Then you are
Tenant.
claiming for occupancy right,
Yes,
which is adverse to the owner.
yes.
And why you have not made party?
My lord,
I'm
I am
not-
claiming on just, my lord, kindly see one thing, my lord.
No, the names are there.
Yes, my lord.
The patta where you are seeking occupancy right. Why this should not be treated as a case of
My
non-joinder?
lord, I am just praying for the disposal of, my lord, page
No,
52.
disposal of the case cannot be.
52,
We
my
are
lord.
not here for disposal.
Direction to the deputy commissioner.
I am making it clear to all the council, we are not here for disposal of representation. Because lot of many times mischief is committed. We are here to decide the issue. So if you are claiming occupancy right, meaning thereby as on date, you are not having occupancy right.
Yes, my lord, that is there. my lord.
So meaning thereby there is existence of patadar. And in case you are claiming occupancy right, so it is a case which is adverse to the patadars. Is it not?
Yes, my lord, it is there.
Then they are to be made parties.
Yes. Yes.
As simple as that. Otherwise, I will be dismissing it for non-joiner of party.
Yes, my lord, I may be allowed to, my lord, make them put party, my lord.
Is there any mention or not here?
Yes, my lord, Banamali Das, mention, my lord, in the petition.
File I.
Yes,
File I. We are not issuing notice in this manner. It is clear case of non-joiner. Yes, what do you say?
Yes, absolutely. Yes. They are claiming rights through the
Through the
owner.
owner whose names are existing in the patta.
Yes.
So
But my lord,
you are claiming occupancy right adverse to the pattadars. Is it not?
yes,
Then
kindly see, my lord, page 42 for the time being, my lord, kindly see. Report of circle officer, my lord. Page 42, my lord, next set, my lord. As per the letter dated 14/12/17 issued by the Additional Deputy Commissioner Certain Branch, by letter number so and so, letter 4/1/2017, after proper verification, it is founded, Sri Ripon Gai, the petitioner, my lord, so and so, has been possessing total 26 bighas, 4 kathas, 12 places land, out of which 20
so what
bighas.
do you want?
My lord, therefore, as per provision of Assam Temporary Settled Areas Tenancy Act, and also paying the land revenue as a Raiti Patta under section 6 of Assam
No,
Temporary Settled Areas.
read
Can
petition
be-
without non-gender of parties
Yes,
will
that is
create
there.
many complications. We are not going to
Yes,
enter in this read petition.
yes, my lord, I will make
Not
them.
going to, otherwise I'll be dismissing it for that.
My lord, I may be allowed to make them party.
Mr. R.H. Chauhan, Learned Counsel for the petition, has paid for some time to file additional pleadings in order to bring the Patadas on record under against whom the petitioner is claiming occupancy rights. MS Mr. A. Borsite, R1. R1. Revenue, huh? Queen Pepper, huh? S. Burwa,
2, 3, and
2 and 3 are present. Please the case after eviction I did.
Oblige.
Raise the case in the motion, raise the case. Raise the case after week.
Oblige.
Item number 6.
My lord, in this case, my lord, petitioner filed this writ petition, my lord, for my lord jurisdiction, my lord. My lord, what happened, my lord, in this case, my lord, petitioners, my lord, purchased a vehicle, my lord, where my lord, the loan was.
Yes,
my
I
lord,
have understood. I have understood.
lordship, my lord. My lord, everything, my lord,
Yesterday also, this kind of petition has come.
my lord, one of the case, my lord, as a lordship, our, my lord, one of the judgment, my lord, Honorable Supreme Court, that is a Majidhya judgment, my lord, in the
No, Naveen Majid, huh?
lordship, in that aspect, my lord, one of the, my lord, our High Court, my lord. My lord, can you?
You just hand over. Okay, I have to go through it because exercising jurisdiction beyond territorial jurisdiction. This has to be examined. Another case that yesterday or the counsel was Mr. Kamuli. SN Kamuli. Now noticeably, the same respondent number 6, they have now adopting a procedure. They have devised a procedure of instituting complaint case in Calcutta.
Yes.
This I have found.
Yes. Where, my lord, the head office, my lord, at Chennai, my lord.
Another petition has been filed. So there, the state of West Bengal was not made a party, but same type of case. Vehicle or what?
Vehicle, my lord. Is a dumper vehicle, my lord. Only, my lord, he-
What we will intend to do, we have received, or we'll put it on third. Let me go through it.
Right.
All these, there are other decisions also.
Lord.
Just because
Yes.
Navin Chandra Manjita is Meghalaya and Bombay,
Lordship.
but there are subsequent decisions, so let me go through it in the meantime.
How High Court another two judgment, my lord.
Honorable Justice Ujjwal Bhuyan's judgment is
Yes,
also
Lord.
there.
Subsequently, Prasad, depend on it.
Let us see.
Lord.
When is your warrant has been issued?
Warrant, my lord, that is as per the order, my lord, 11/9, my lord.
11/9.
That is my lord, page 41, my lord, tell see, my lord. 406 and 420, my lord. Section, my lord. The type copy, my lord.
Your agreement executed in Guwahati?
In Shipsagar, my lord.
Assam?
Yes, Lord, Shipsagar district, my lord. And one of the branch office, my lord, is Shipsagar, my lord.
Where is your agreement?
My lord, agreement I have not annexed, my lord.
Huh?
Uh,
Do you have a copy of the agreement or not?
No, my lord, there's a agreement number already I have.
Where is that?
That is, my lord.
Where is your statement?
Yes, lordship. My lord, that is, my lord, kindly see, my lord, page 9, lordship. Page 8, last part, my lord. Page 8, my lord, last part. It is very much pertinent to mention herein that no part of cause of action relating to commission of the alleged offence had arisen within the territorial jurisdiction of the learned court of 19 Metropolitan Magistrate Kolkata. In it must firstly the loan agreement being number so and so between the petitioner number 1 with the respondent company was agreed in Shipsagar, my lord.
Never received any summons. Yes. Heard Mr. Ellen Dingia. Learned counsel for the petitioner. Petitioners. Mr. N. Goswami. Junior Government Advocate Assam for the respondent number 1, 2, and 3. The instant writ petition under Article 226 of the Constitution of India has been preferred, seeking quashing of the criminal proceedings of complaint case number CS stroke 80262 of 2023, instituted and presently pending in the Court of Learned 19th. Where is the summon or warrant?
My lord, page 41, my lord. Type copy, my lord. 19 Court, Calcutta, Metropolitan Magistrate.
Metropolitan Court of Learned, Metropolitan Magistrate, 19th Court, Calcutta, not Kolkata. Oh, within bracket Kolkata. West Bank. Full stop. The said complaint case has been filed by the respondent number 3 against the, against whom?
Respondent number 6, my lord.
No, filed by respondent number 6, but against both or what?
Wife also, my lord.
Huh?
Wife also, my lord.
Against the petitioners alleging commission of offences under section 406, 420, 120B, 34, Indian Penal Code. Full stop. Para, it is the case of the petitioners that in March 2021, the petitioner number 1 availed financial facility amounting to rupees 11,80,279 from the respondent number 6 who has, which organization has a branch office at Sibsagar, for the purpose of purchasing a dumper vehicle. Full stop. The financial facility was extended by the respondent number 6 to the petitioner number 1 on 23/2021, and the petitioner number 1 was supposed to deposit EMIs against the financial facility so extended, at rupees 27,481 from the period during the period from 20/04/2021 to 20/02/2026. Full stop. For the purpose of extending the financial facility, a loan agreement between the petition number 1 and the respondent number 6 was also executed at Sibsagar. Was also executed. It is the case of the petitioners that, the petitioners have asserted that the said loan agreement was executed at Sibsagar. As during the period of COVID pandemic, the business of the petitioners received setbacks. There was some irregularity in depositing the EMIs to the respondent number 6. Is a dumper vehicle bearing registration number AS04/BC-6917. Some irregularity in paying the so after June 2021. As lockdown was declared in the entire country, the petitioner number 1 could not fly his dumper vehicle due to restrictions imposed by the central government and the state government in respect of public transport system. The petitioners have recently received information to the effect that the respondent number 6 has instituted the state aforementioned criminal proceedings at before the court in Calcutta and the learned trying magistrate in the course of the said proceedings, has issued an warrant of arrest under section 75, a warrant of arrest on 11/9/2023. It is a case of the petitioners that the petitioners did not receive any summon at any point prior to 11/9/2023, that is, the date of issuance of the warrant of arrest. Fair. As the learned court at Calcutta does not have any jurisdiction to try any dispute between the petitioner number 1, petition number 1 and the respondent number 6, because of lack of cause of action at that place, the petitioners have preferred the present writ petition. Post of apart from issuing warrant of arrest against the petition number 1, the learned court has also issued warrant of arrest against the petition number 2. She was guarantor or what?
Yes, Lordship.
As a guarantor in the loan agreement. Also. Here paragraph 3 to put for you. Learned counsel for the petitioner has submitted that though the case against the petitioners is criminal proceedings against the petitioner is pending in the Calcutta court, which is under the jurisdiction of the Calcutta High Court, this High Court can also exercise jurisdiction in respect to the seat criminal proceedings, in view of the cause of action arising within the territorial jurisdiction of this court. As the entire issue is relatable to the loan agreement executed within the territorial jurisdiction of this court. The petitioner number 1 has availed a financial facility. It is further submitted that the petitioner number 1 has availed a financial facility only from the branch the respondent number 6 is running at Sipsagar. In support of his submissions, the learned counsel for the petitioners has relied upon the decisions of this court, in the case of so and so. Supreme Court in Naveen Chandra Majita and so and so. Issue notice returnable in 4 weeks as Mr. Goswami has appeared and accepted. Notice for 1 to 3. Extra copies, no formal notice. The petitioner shall take steps for service of notice upon the respondent number. Four, 5, and 6 by registered post with AD within 2 working days. Returnable date February. It is provided that till the next date of listing, the respondents shall not act upon the warrant of arrest issued by the Court of Learned Metropolitan Magistrate, 19th Court, Calcutta, in complaint case number so and so. What is the question? CS A02 62 2023.
The respondent, my lord, also, my lord, they issued a letter, my lord, to threaten, my lord, any moment, my lord, they custody, my lord, the vehicle, my lord. I have annexed, my lord, that before filing, my lord, page 47, my lord.
That is different. That power has, they have, so that Supreme Court has. So for initiation of criminal proceeding is one matter at Calcutta. That power to repossess is there, and that has been confirmed by the Supreme Court. The method is different.
Yes. Master.
Item number 7.
Violation of Rule 9, Assam Services Discipline and Appeal Rules, 1964. Discipline and Appeal Rules.
Yes, my lord, yeah.
We are sitting in bench 5.
Oh, my lord, this,
Disciplinary proceeding.
yeah, disciplinary proceeding.
Government servant.
Government servant. They have listed, my lord, here, my lord.
Cannot be listed.
And I have mentioned in the bench 3, my lord. But they have, my lord, I don't know why, my lord, but the thing is that, my lord,
Learned counsel for the petitioner and Mr. B. Raswa, Learned standing counsel, Corporation Department, for the respondent number 1, 2, 3, 4,
1 to
5, Mr. N. Goswami, Learned Junior Government, some for the respondent number 6, 7, 8, and 8. Full stop. The learned counsel for the parties have submitted that the subject matter of the petition is a disciplinary proceeding initiated against the petitioner under the
Rule 7.
under Rule 7 of the Assam Discipline within bracket Assam Services within bracket
Sorry, ma'am, Rule 9.
Rules 1964.
Rule 9, 7 is punishment, my lord. Rule 9.
Rule 9.
7 is punishment.
And as such, the writ petition is to be listed before bench 3. The office to ascertain the subject matter of writ petition and list the case accordingly. On 3 or 5, urgency?
The urgency is there, my lord. Because they
3,
will
1.
go with the
3, 1.
execute the report, my lord.
Just because cooperative society, they
Yes, my lord. I have mentioned, I make a mention there also in court number 5, my lord.
Okay.
Supplementary list for motion item number 24. Please, your lordship.
Yes, madam, contempt case.
Yes, lordship.
What
we
is
are
the
finding-
direction?
Lordship, the order is at page 9, is available at page 9, and the relevant portion is at page 11.
Not following due process.
Yes, lordship.
Hard MS,
D Devi.
B Devi,
D.
D Devi, learned counsel for the petition. The petitioners have preferred the instant contempt application under alleging disobedience, alleging non-compliance of the direction given in an order dated 19/10/2023, passed in a writ petition from WBC number 6315/2022. It has been averred that the order dated 19/10/2023 was duly brought to the knowledge of the respondents impleaded in the present contempt petition. Issue notice returnable in courts, the petitioners returnable the petitioner shall be for service of notice by registered post with AD within 2 hours.
Item number 25.
May I please your lordship? Lordship, my senior is on late. The matter may be passed over for time being. I'm appearing for the caveat.
Mr. Sinha, you are still not filing amended cost title. What is the previous order? Para 6.
Yes, my lord.
Para 6. Office to cause necessary correction in the cost title of the connected petition on filing of an amended cost title by the learned counsel for the applicant's petitions in terms of the notification dated 79 dated 19/6/2023 by tomorrow and leaves the petition on 22/12/2023.
I mistook, my, I mistaken.
Why every 5 times this has happened?
This petition, my lord. I will do it, my lord, but today is the last, because on the Sunday there is election, my lord.
I have seen you that you do not.
No, I did, I should complete, my lord, violation, because
Violation is different. You are not,
I will
following the direction of this code also.
Sorry, I will file, my lord. I will file. Sorry, I did not, my
How
lord.
many times this petition is listed?
Yes, my lord. This is getting disturbed, my lord. I don't know. This way or that way, or this way, my lord.
Some way or other, every time
Yes,
you find, and there is a note now again.
I will do it. I will do it, man. Today itself I do it, man. Today, by today, my lord, I will make the constitutional amendment, man.
That petitioner has not submitted.
Yes, but actually, sorry, I did mistake, my lord.
Yes, who is your senior?
MJ Kadi.
We may continue.
He's in the another court.
Sunday is there, my lord.
Okay, after some time.
Obligation.
Let him come.
26.
In this case, your lordship, although we have made several prayers, your lordship, and essentially our grievance is for not holding your lordship, they one petitioner, your lordship, holding the election to the board of directors, your lordship, and AGM, your lordship. By operation of law, your
This
lordship,
one.
although your lordship,
That Escard Bank, something
lordship,
like that.
your lordship, at one point of time, probably your lordship, they as a
Reserve Bank of India.
Reserve Bank of India.
I was,
Lords.
I don't think
Lords.
it should be. It is a continuation of that.
Continuation.
Okay. Please the case before any other event.
Lords.
Oh, that was the case mentioned yesterday.
No, your lordship, no.
Huh?
That was your lordship has taken up yesterday itself.
No, another case.
Lordship.
Because I directed to list after vacation.
Lords.
27.
Obliged.
It will be taken after vacation when the petitioner is not there.
Then you take instruction.
Not ready.
Well, the matter relates to, my lord, disconnection of water supply connection, my lord,
Mr.
without giving any notice.
You get instruction. Immediately, we are not issuing any notice. Let him take instruction. We will try to. We try to adjudicate the issue.
My lord.
Issuance of notice will take some time. You take instruction as to why.
Yes, my lord. Without notice, let them do something, my lord.
And otherwise, like electricity.
Essential service, my lord.
And if he is an occupant of the premise.
Yes, still I am occupant,
With
my lord.
some kind of right. And in that case, at least, this should not be disrupted.
Yes, I am ready to pay any amount, but if
It is
necessary, my
as
lord.
good as electricity.
Yes, my lord.
In fact, more
Yes, my lord.
important than electricity,
Without that,
right?
nobody will die, my lord. Without water, will die, my lord.
Heard Mr. S.K. Mukta, Learned Counsel for the petitioner, and Mr. S. Bora. Municipal also?
No, my lord.
Oh. Mr. S. Burua, Learned Junior Government Advocate Assam for the respondent number 1, and Mr.
I'm for
S. Bora, Learned Standing Counsel, GMC for the respondent number 2. The petitioner has alleged that the water supply
Yes, ma'am.
to the premise described in paragraph 3 of the writ petition, has been suddenly what? Withdrawn?
Disconnected, my lord.
Disconnected from by the authorities in the by the authorities under the respondent number 2. The petitioner has projected that he is a bona fide occupant of the said premises.
Without notice, that may be recorded. Without notice, my lord.
And the water supply connection has been disconnected. Water supply has been disconnected without any kind of notice.
Yes, ma'am.
Any kind of prior notice.
The violation of 222, my lord.
Prior notice. Mr. Bora, standing house, GMC, has sought listing of the case on 3rd, 4th, or 5th.
Let it be on 4th, my lord.
4th.
Oblige, my lord.
5th.
5th, my lord. My lord. Okay.
5th of January 2024 in order to obtain instructions in the matter.
The government may be reflected in the
Name of government, Learned Government Advocate,
My pendency shall not be bar, my lord.
be reflected in the respondent side in the clause. You use your good office, I will not observe anything. You use your good
Yes, my
office,
lord.
Mr. Bora.
Oblige.
It is hardly a water connection.
Item number 28.
Yeah, please, your lordship. The petitioner lordship purchased a small plot of land, my lord. Also, can you see deed, purchase deed, page 20, my.
There is standing counsel in NIP.
No, my lord.
It appears.
Yes, my lord, sometimes.
Some standing counsel.
Is an IPS lead. Register for a
Perhaps.
notice maybe issued in the meantime, lordship, after receiving notice, NIT engaged, my lord.
Huh?
After notice, receiving the notice, my lord, NIT engaged the council. My lord.
Where you are alleging, what you are alleging?
Lordship and this, after purchasing this land, my lord.
No, what you are alleging? This
Lordship,
paragraph?
kindly see, allegation, lordship, kindly see, at page 61, my lord.
Basic allegation is that, my lord, the respondent number for NIT, petitioner is making some construction in his own plot of land, purchase plot of land. Allegation in the writ petition is that, my lord, the NIT authorities are causing obstruction. That is the precise issue. Some civil suit has also, my lord, been decreed that, my lord, will find at page 27 of the writ petition.
Between whom?
Between, my lord,
That,
Not NIT.
not an idea, but petitioner appeared as the defendant there, my lord. Previously declared in my favor, my lord.
No, civil suit was declared in the favor of the erstwhile owner,
Oh, no, my lord.
from whom you have purchased the
My
plot.
lord. Accordingly, my lords, those persons purchased the nearby the NIT, my lord. The NIT always disturb, my lord. Accordingly, one rules of my lord filed a petition with the Honorable High Court, my lord. I went next is page 62, my lord. Similarly, my lord, he was also obstructed, my lord. He filed a petition with the Honorable High Court, my lord. When High Court passed an order, my lord, 11%, page 63, my lord.
No, that is a different case. Petition was issued impugn notice by which building construction has been sought to be withdrawn.
NIT lost to
Plus NIT may be a case. NIT may be your neighbor.
my lord, NIT filed complaint with the development authority. Development authority, my lord, on this.
At least they will issue also notice on the interim prayer.
And I am praying for similar prayer,
You
my
take
lord.
steps
Yes.
on NIT by registered post as
My
well as by
Yeah.
Dusty.
My lord.
We'll fix a date, we'll pass order with the before the council of the respondent NIT. Oh, sorry, NIT.
Yes, because question of fact is involved, that can be better known, my lord. Only
No, the other case is different.
that is different.
Other case is that impugn notice by which building permission has been sought to be withdrawn.
That stage has not yet come in this case.
It is NIT against whom you are alleging.
Yes, my lord.
Heard.
Ultimately, NIT, my lord, disturbed.
Heard Mr. J. U. N. M. Loskar. Counsel for the petitioner. Mr. R. Borbujari. Revenue 1.
Respondent 1, my lord.
S. Borua. Junior Government Advocate 2. Full stop. The petitioner has asserted that he is the owner and in possession of a plot of land measuring 4 kathas, 2 chataks, covered by tag number 172 and second RS Patta number 10/5, situate within Harakai Grant. Subject. It has been stated that the subject plot has been purchased by the petitioner from its erstwhile owner by way of a registered sale deed on 29/3/2023. And since then, he has been residing thereon. After obtaining a house building permission from the respondent number 3 on 26/2023, the petitioner started construction of a building in terms of the said permission. The petitioner has been undertaking the construction, but time to time, the personnel from the respondent number 4, by coming to the subject plot, has been obstructing, has been putting obstructions to the construction works of the petitioner. Hence the writ petition. As Mr. Issue notice returnable on. as Mr. Borpuzari and Borua. The petitioner shall take steps for service of notice upon the respond number 3 as well and the respond number 4 by registered post with AD within 2 working days. In addition, the petitioner as requested, in addition, the petitioner shall take steps for service of notice upon the respond number 3 as well as the respond number 4 by way of justice which is to be the client's affidavit. The notice be also issued on the interim period. To stop the prayer for interim relief. The prayer for interim relief will be considered on the returning.
Item number 29.
May I please? Lordship matter pertaining to
Ex-gratia.
here lordship petitioner is the wife of the deceased.
Who?
Wife of the deceased.
Wife of the deceased.
Let Ranjit.
Ranjit Kalita. Date
Application
of
date.
accident?
Incident took place 12/12/2022.
2022. Representation?
28/08/2022.
28/8/2023.
Yes, Lordship.
N. Bordoloi. SI account petitioner. N. Bordoloi. Revenue 1. R. Borpuzari. Finance 2. MSS Borua. Junior Government Advocate 3, 4, and 5. Notice returnable in 4 weeks. Steps no formal notice within 2 days. Extra copy.
Lordship.
Item number 30.
Lordship, item number 30 also said here next of kin of the deceased.
The petitioners have claimed that they are next of kin of one. Iqbal. Iqbal or Iqbal? What is this?
Both Lordship.
Huh?
Iqbal.
IK.
Yes.
IK. BUL.
Yes, Lordship. And
Iqbal.
Iqbal and Iqbal. they are both named.
IQBAL or BUL?
BU.
BUL. Hussein. Date of death 3/9/2022. Representation
28/08/2022.
28/8/2023. SI account petitioner N. Boroloi Revenue Disaster 1. Borpuzari 2. S. Borua 3, 4, 5, 6.
Obliged.
31.
May I please, Your Lordship? Well, I have purchased a flat which is a 20-year-old, my lord.
Flat.
My lord, yes. It requires certain repair. And when I started, they have served me with a stop notice.
Permission?
Actually, my lord, permission is not required for requirement, my lord. The rule is there, my lord.
Which notice? Dhubri Municipal Board?
Yes, my lord.
You know, if I'm right.
My lord, section 14, my lord.
Section 14.
14. Rule 14, sorry, rule 14.
I don't know what kind of repairing, because there in some other.
My lord, otherwise, you
Some
know,
other rules also, the permission required. This is what Notified Urban Area Building Rules 2015.
other than Guwahati, my lord, this is.
Okay, get them served immediately. We don't know what kind of repair. Since they are
Not-
asking you that building permission is required.
My lord, even if, my lord. I
And
have-
secondly,
my lord.
you are directed to submit relevant documents.
Yes, my lord.
It is not that.
Yes, thereafter, my lord.
Huh?
Thereafter,
Did you submit?
Yes, my lord. Yes. Page 34, my lord. Page 34.
And
Page 34 was submitted. Thereafter, again, when they did not do anything, my lord. Page 35, my lord.
now where is the stop construction?
Yes. At page below 32. That is the type copy.
Okay. Third, Mr. So basically your reply has not been considered
My lord, no, totally not.
and not finalized.
Yes. Otherwise, my lord, as per rule, it is
We
not.
see that they are also saying about rules.
My lord,
You are also saying about rules.
otherwise, my lord,
You have shown one rules, right?
my lord.
They are also saying that submit building permission. Whether their case is correct or not, let us see. Hard, Mr. S. Sahu, Learned Counsel for the petitioners. Who is housing urban?
P Nayak.
Okay, P. Nayak. Standing as urban affairs. 1. Okay. The petitioners have stated that they purchased a plate measuring 1180 square feet in the first floor of a Z+2 RCC building by way of a registered sale deed. And after purchase, they have been living in the said trade. As some repairs were required to be undertaken, they started such repairing works. Agreed by service of a notice from the respondent to municipal board. We have a notice dated 3/4/2022 and non-consideration of the reply submitted by the petitioners in response to the state notice. The petitioners have required the instant repetition by the notice dated 3/4/2023. The respondent number 3 had directed the petitioner number 1 or petitioners to stop the then ongoing construction works in the RCC building. The petitioners were also directed to submit building permission and other relevant documents before the respondent number 3 within a period of 3 days, therefore, failing which necessary measures would be taken. The petitioners have stated that as no permission is required under the provisions of the Assam notified urban areas within bracket other than Guwahati bracket close building rules 2014, more particularly section rule 14 thereof, to undertake any repair works, the petitioners submitted representations before the respondent number. The petitioners duly submitted their reply to the said so-called notice on 7/4/2023, highlighting replies on 7/4/2023 and extra 5 and on 15/6/2023 highlighting such provision of law to stop. Yet, command the respondent municipal board authorities has not taken any final decision till date. As a result, the petitioners have not been able to continue the repair works which are necessary for the building. Full stop. Issue notice returnable on so. Notice be also issued on the interim pair as Mr. Soin Nayak extra copy. The petitioner shall take states for service of notice 2, 3, and 4. You want Dusty also?
Below
Dusty?
Dusty maybe.
Okay, I got to initially get you Dusty. Returnable. You want this?
Yes. Otherwise, my lord, can be kept with record.
Better. এবার নামটা লিখে দিব ঠিক দেখে বুঝিব
Item number 32.
pay for interim relief will be considered not a returnable debt.
My lord, that requisition matter.
Any idea?
Lordship, in this matter, we have sent for instruction. It is coming in just 10 minutes time, maybe taken up after the motion list.
33.
Please, Your Lordship. Lordship, the petitioner herein has inherited a plot of land from his deceased father, and deceased father.
Inherited? What kind of land inherited?
Yes, that is a now the position
Government land.
Government land inherited.
That's he purchased it for original khati under in the year.
So you are in possession of
Yes,
the
sir.
government land since the date of your father,
From
since the time of your father or grandfather.
yes, Lordship.
But government land,
Government land.
that does not call inheritance.
Yes, Lordship.
Yes.
And thereafter, the petitioner had applied for allotment in her name in the year 2010, Lordship. Lordship, may kindly be pleased to see page 24, annexure 2. There was an earlier round of litigation, and the right of possession, by way of possession and settlement was decided by this order, Lordship.
Page 24.
Page 24. It is after the order of this honorable
Deputy Commissioner.
Lordship. And
Regarding allotment.
allotment, Lordship.
Okay.
Below heard both the parties. Both the parties mean from whom the petitioner's father had purchased the land and heard the Latmandal too. May I read, Lordship? On careful perusal of all relevant records, it is revealed that the land in question is a government trust land. It has also been observed that late Jyoti Mahmud Sheikh, the father of Srimati Hazira Bewa, the petitioner of the instant case, had purchased the land from the relatives oblique inheritance of the Khatiandar to private unregistered deeds. Srimati Hazira Bewa produced the Bedaholi Jorimana payment receipts, which shows that the late father Jyoti Mahmud Sheikh had also paid the land revenue Bedaholi Jorimana of the disputed land in the year 1997, 98, 99, 2000, 2001, 2002, 2002, 3, 4, 5, 5, 6. Srimati Hazira Bewa and others have also applied to SDO Civil Bilasipara for allotment of the land in question in the year 2010. And the same was forwarded to ASO support for inquiry and report file number so and so. Thereafter, the process of allotment was initiated, and it was before the land advisory committee since the year 2018, Lordship, and it was forwarded to the higher authority by the sub-divisional level land advisory committee in its meeting dated 21/10/2020 for further approval, Lordship. And
which page?
It is at Lordship.
Okay. So
Starts from
your matter was thereafter forwarded to subdivisional officer proposal,
Lordship.
then placed before SDLAC
Yes, Lordship.
Is it so?
Yes, Lordship.
Where is your name? Hazera Bewa, page 29?
Page 29 starts and mine name is at page 33, Lordship.
33.
Below.
33.
Below nothing portion, Lordship. As per past pending proposals. Below, Lordship. Below the start, Lordship. As per past pending proposals held on 24/2020.
Page 33.
Page 33, Lordship. Below the start, there is a nothing, Lordship.
Pending proposal.
Pending proposal.
Which one? Number one.
Number one, yes, Lordship. As WPC 451/2012.
The higher authority.
Yes, Lordship. Thereafter, the office of the respondent number one, that is, commissioner had issued this letter at page 34 and 35, Lordship. This is the type copy. To consider the proposal as per land policy 2019. And
why you are aggrieved then?
My prayer is to settle the allot the land lordship as per land policy 1989.
Yes, how you are aggrieved?
Yes, sir. As I have as page 27 lordship annexure 4. I have inherited or I have now I am in possession along with my family members lordship of the particular plot of land and this is the person's lordship.
The position is not disputed by the.
It is not in dispute, lordship.
So what is the difference between 2017 policy or 1989 policy, perhaps 89, right?
Yes, lordship. As per
and 2019 policy, what difference?
As
and
per
for which
2019
you have a cause of action.
Yes, but as per 2019 policy, I am offered 3 bighas of land, and if it was a 1989 policy, I am going to offer 7. And as though I am a petitioner, single petitioner, but we have 7 applicants, lordship. Of course, 1 or 2 person has died in
Lands are very scarce. Scarce.
Yes, but
Okay, we'll issue notice. That when the proposal was initiated, the policy in vogue was 1989 policy. When the application is being processed at different stages, in the meantime, 2019 policy came. Now it is his case that his case should be considered under 1989 policy. We'll examine which one is correct.
In fact, that annexure 4, my lord, total
Page,
my lord, that is 27. Because the entire family members are claiming. Now, lordship will see at page annexure 4, page 27 at serial number 1, Hazera Bea. She is the petitioner out here.
Page 27.
Yes. Then other persons are also there. Down below, lordship will kindly see 7 bigha 2 kotha. So family means not only an individual under the, in fact, within the ambit of 89 policy also definition of family is there. It includes, my lord,
All are Juti Mahmud.
Yes, lordship.
Now I have seen.
So therefore, in fact, they are getting whatever is available to them under the 89 policy. Anyway,
We have to go by the definition of policy.
Yes, lordship.
Definition of policy. Okay. Heart. Robin and Patel. Learn counsel for the petitioner. Arbor Pujari, Revenue 1, and Goswami.
2, 3, 4, and 5.
2, 3, 4, and 5. It is the case of the petitioner that the petitioner's application for allotment stroke settlement of government of land after acceptance, was considered was accepted and thereafter, the application was the initiation of the process for allotment stroke settlement was started when the land policy L capital P capital of 1989 was in vogue. Full stop. The learned counsel but a petitioner has referred to the letter dated 18/4/2018 Annex report to submit that the proposal for settlement, allotments for settlement of the government custom in favor of the petition was forwarded by the assistant settlement officer to the higher authorities on 18/4/2018, and the processing of the application proposal took much longer time thereafter. Full stop. The petitioner is aggrieved by the communication dated 1/4/2022, Annex 6, whereby the government in the Revenue and Disaster Management Department had directed the Deputy Commissioner to examine, re-examine the proposal for settlement of the government constraint in favor of the petitioner on the basis of the land policy of 2019. Mr. Borpujari, the understanding of revenue by referring to annexer, referring to annexer 4 has submitted that proposals, a number of proposals were forwarded thereby. A number of proposals for settlement in favor of 7 number of persons were forwarded thereby, and all the 7 proposals were for settlement of government constraint in favor of members of the same family.
Same family.
Full stop. According to him, only one settlement proposal from one family can be considered under the land policy.
Well,
Full stop. As in the meantime, the land policy of 1989 has been replaced by the land policy of 2019, the settlement proposal has to be considered in terms of the extant land policy. Issue notice returnable on so and so. As so and so appeared, accepted, no formal notice, extra copies within 2 working days.
Item number 34.
okay.
Your Lordship, I am on behalf of the Mr. H.R. Chaudhary.
My lord.
Hmm.
My lord,
What is your grievance?
grievance, my lord, the rupees 25 lakhs has been sanctioned to uplift my Anganwadi center as a model Anganwadi center, my lord. However, my lord, now we have.
Very good.
Now we have
Who are
noticed.
you?
I am the president of the managing committee of the Anganwadi.
Very good. Updated.
Now, my lord, we have noticed that 3 kilometers away, the one construction project has been started, saying that this model center, the amount which has been sanctioned to development of my model center, my lord, to uplift as a model center, the amount is spending in there, my lord, 3 kilometers away, my lord, which is, my lord, beyond the survey area of our village, my lord.
It's totally arbitrarily
That
managed.
may be a different one.
Not
How?
different one.
How? Where from you are saying so?
Apprehension.
Where from you are saying so?
My lord,
That some construction is going at some place.
Yes.
And that's the money by utilizing that money belongs to you. How?
my lord,
Where from?
my lord, I have collected, my lord,
What
that
collection? Let us see.
I have collected one, page number 28. I have collected, my lord, the photograph of the foundation laying stones board, my lord. This is collected from the contractor, my lord. He is, although, my lord, this is not an official document, but I have collected, my lord. And we have filed our grievances before the district commissioner. And district commissioner admitted this fact that the matter will be inquired into.
Yes.
But nothing is doing, my lord.
You are concerned with what? Model Center 165 Eraligul Tea Estate or Ahmedpur Anganwadi Center?
The name of this center, my lord, Eraligul Tea Estate and Ahmedpur Anganwadi Center.
This is the entire name.
This is the name, my lord. The signboard we have annexed, my lord.
Yes, Mr. Goswami.
Was there file an application before a deputy commissioner lawsuit that is also pending lawsuit.
Have you filed any RTI?
Not, my lord. Just we have noticed, my lord, accordingly, we have put before the district commissioner. District commissioner assured us that matter will be inquired into.
Then it was submitted on 15/12. Why you are in such a hurry?
No, my lord, 4/12.
Paragraph page 30.
This is filed before the minister.
Huh?
District commissioner before 30/11. 30/11, my lord.
Oh.
On 30/11, my lord.
Yes, Mr. Goswami. Yes, tell me.
I have the instruction lawsuit.
Huh?
I have the instruction there.
This kind of repetition should not be kept pending, whatever, one way or the other. Pardon me, Mr. HR, Learned Counsel Board of Petition. And Mr. and Goswami, Junior Man. For all the respondents?
Lordship.
Alleging that found fund amounting to rupees 25, 5 lakhs, sanction for uplifting for upgrading the upgrading 165 number Eraligul AERALIGOOL within bracket D full stop E and Ahmedpur Anganwadi Center are being utilized for construction of another building outside the jurisdiction of the Anganwadi Center. The petitioner as the president of Eraligul within bracket T, Ahmedpur Anganwadi Center has prepared the repetition. Issue notice returnable instruction as Kusami appeared accepted. Para. As the petitioner has also stated that a representation was submitted by the petitioner on behalf of the
President.
on behalf of the
Page 29.
on behalf of the what?
On behalf of the Anganwadi Center.
On behalf of the said Anganwadi Center on 29/11/2023, and the receipt of the said representation was duly acknowledged. Receipt of the said representation on 30/11/2013 and Roman and 4/12/2023 was duly acknowledged. Full stop. It is therefore observed that the pendency of the repetition shall not be a bar for the respondent number 3 to dispose of the representation with due intimation to the petition.
Till then, my lord, that construction work may be stayed, my lord.
I don't know. You have annexed one document
Yes, Lord. This Lord.
which is also doubtful.
Yes.
I am in occupation of a government land since 1982. Obviously, we don't have no legal right to be over there. But then the only issue is whether without following a due process of law, can I be ejected from there? Now, my lord, this is the third round of litigation. My lord may see the order of this honorable court at page 46. The relevant portion, my lord will find at page 49, paragraph 6. The entire history has been narrated since 1982, etc., etc. And the relevant
6.
para 6, page 49. And I read, under such circumstances, it is the opinion of this court that no interference is called for to the impugned notices dated 21/6/2021. Be that as it may, this court further finds it relevant to observe before concluding that the respondent authorities shall be at liberty to take such steps as permissible under law by taking into account the order dated 18/2/2019 passed in WPC such and such. The interim order so passed on 29/6/21 stands merged with this order, taking into account the extent of the respondents and liberty is granted to the respondents aforesaid. Now, my lord, what is this order dated 18/2/2019? This, my lord, will find at page 26. 26, the order begins. The relevant portion, page 28, paragraph 7.
27, paragraph.
Paragraph 7, page 28, the relevant page. In view of the above, this writ petition is disposed of by directing that the petitioner in question shall not be evicted from the land under his possession without following the due process of law and without issuing notice under Rule 18(3) of the settlement rules as indicated above. The writ petition is accordingly disposed of. Now the trigger. The trigger, my lord, is page 50 and page 54. The page 50, my lord, will see this is issued by Chief Executive Officer of the Guwahati Biotech Park. It is dated 28th of November 2023.
53.
Page 51st.
Page 50.
This is the first trigger.
Okay.
Annexure 7, page 50, 50. Dated 28th of November 2023. Received by me on 6th of December. But anyway, I'm going into the contents. Annexure 7. Reference to the subject cited above, this is to inform you that the land measuring 20 biga under lag number such and such has been handed over to Guwahati Biotech Park wide such and such, and the record correction of the land has been done accordingly such and such. It has been noticed that you are occupying a part of the said allotted land by constructing sheds. Therefore, it is difficult for Guwahati Biotech Park to complete this earth filling and boundary wall work undertaken such and such. In view of the above, you are requested to furnish the valid document in support of the land you are occupying to the undersigned within 3 days. Otherwise, you are requested to vacate the place within 15 days from the receipt of this letter. Then, my lord, since I received it on 6th of December, I submitted a detailed representation, and I also furnished, yes, detailed representation, annexure 8, my lord will find at page 51, furnishing the document, etc. And this was followed by the impugned notice, which is at annexure 9, page 54. The original copy is in Assamese, the translated copy at page 54. My lord doesn't require a translated copy, so my lord may see it in English.
So apparently in
This is
violation
about
of
this. Rule
apparently in
18, sub rule 3.
violation of
Rule 18.
order dated 18 to 2009.
Number 1. Number 2, the very notice itself is in violation of Rule 18, sub rule 3, in as much as circle officer, not Guwahati Revenue Circle, who has issued the impugned notice dated 20th December 2023, is not a competent authority. Under Rule 18, sub rule 3, my lord, it is a deputy commissioner. So, my lord, the very notice suffers from the inherent lack of jurisdiction. It's a nullity. Rule 18, sub rule 3 may kindly be seen, my lord. Ejectment. Rule 3A, small a, and then 3B. The rules framed under the Assam Land Revenue Regulation. But I'm giving my copy.
First bullet. First bullet.
3A and 3B. Entire procedure has been laid down. But I have given my copy. The marked portions are there. 18.3A, Roman 1, and 18.3B. Rule 18, sub rule 1 begins with power of deputy commissioner. Rule 18, sub rule 3A and B.
Yes.
It begins with, my lord, Rule 18, sub rule 1, referring to deputy commissioner. The power of deputy commissioner to eject.
That is 1. Rule 1.
Yes. Then Rule 3A may kindly be seen. This process has not been followed at all. In fact, the authority that has issued the notice is not competent to do so. The circle officer. And the CEO both are under challenge. Page 50 and page 54, both the notices are under challenge.
Yes, Mr. Proposal.
That is it.
At least you were directed as per page 28 to follow 18.3.
True.
That order is in operation.
Now, my lord,
The 18.3 requires 15 days.
yes, so the post the decision of this honorable court, 2 notices have been issued. One lordship will find at page number 50.
That is why an authority who
That is by the, my lord, I am submitting. It is, my lord, issued by Kirti Jalli IAS, Chief Executive Officer, who is also the Deputy Commissioner of, I mean.
No, he is
No,
in capacity of chief executive.
Absolutely. No, my lord, I am just pointing it out. So I am not defending this one. Let us now come to, my lord, page 54. Page 54, notice has been issued by the circle officer. Lordship is aware of the decision in Tahir Ali, my lord, that this honorable court has taken cognizance of a notification issued by the government of Assam in the year 2010, whereby the power under Rule 18 has been delegated to the office of the circles officer also. My learned senior colleague is not aware of that. I can't help it. Then, so far as, my lord, this page 54 is there, my lord, the period for vacating is 3 days. It ought to have been 15 days. That is my humble suggestion.
And then, my lord, the procedural parts are also there. Lordship may see 3B, the manner in which notice is to be served. It is to be placed at the situs. All the formalities are there. Nothing has been followed at all.
Time being, this should be suspended, but it is up to you to follow at least page 28, which is operating between these same parties.
Same position.
There is no doubt about it. Paragraph 7, paragraph 7.
So therefore, my lord, page 54, I do not find any infirmity. Lordship will accord my submission, save and accept the fact that only 3 days time has been.
So it is in violation.
That is the legal infirmity. I must fairly
You know,
submit.
I would, in addition, I would submit that by itself is not the only legal infirmity. The legal infirmity is also about the procedure to be followed, namely the requirement of 18.3B and 18.3A.
what
Where
you
have you
say
served the
now?
notice? How you have served the notice?
State council, this should remain. Case 55 should remain. Case 55, I am reading the vernacular one.
ইয়াৰ দ্বাৰা আপোনাক জনোৱা যায় যে উত্তৰ গুৱাহাটী ৰাজহ চক্ৰৰ অন্তৰ্গত শিলা সেন্দুৰীগোপা মৌজাৰ নমলিজলা গাঁৱৰ চৰকাৰী 305 দাগৰ জমিত বায়'টেক পাৰ্কৰ নামত আবণ্টিত ভূমিত আপুনি বেদখল কৰা পৰিলক্ষিত হোৱা দেখা যায়। সেয়ে উক্ত জমিত আপোনাৰ দখল অহা 3 দিনৰ ভিতৰত খালী কৰিবলৈ এই জাননী যোগে জনোৱা হ'ল।
Now come to page 28.
28.
8. Starts from 26.
Yes. Paragraph 6, 28. Paragraph 6, 28.
Paragraph 6.
Yes, be that
And
as
7.
Yes. Be that as it may, the eviction process has to be preceded by notice under Rule 18.3 of the Settlement Rule. So in absence of the same, an eviction process will not be legally sustainable.
So
this is
should we proceed with the writ petition or should we close the writ petition? That is what I'm asking.
Yes.
Should we close the writ petition today itself or we should notice? Heard Mr. P. K. Roy, your counsel assisted by Mr. R.J. Daslan, counsel.
Lordship can close it today with an observation.
My lord,
Lordship will
there
interfere.
is a procedural aspect also because notice is to be put at the place.
No,
And
if they are
he has
considering
received it.
that this is not sustainable in view of,
very well, very well.
then we can close the writ
Very well.
petition.
By quashing the, my lord, the impugn notices.
They are conceding it.
Very well. Very well.
Considering, my lord, that is my respectful submission.
They are conceding it is not, it is in clear violation because paragraph 6 says Rule 18.3, eviction process has to be preceded by notice under Rule 18.3.
Very well. Very well.
And one of the condition, we are not going into other, that 15 days notice.
Yes.
This is clearly in violation and that order is still in operation.
Very good.
Absolutely. Otherwise, he has every knowledge of the notice. He is well aware of the notice. Everything is there, my lord.
Heard Mr. P. K.
Save and accept this 3 days.
Learn it. And the process, procedure. That is up to you. That you will follow the procedure.
Absolutely.
We'll say that.
Absolutely. Lordship will also kindly observe, my lord, the circle officer has the jurisdiction.
Will not
That's
require
what
to
I have to
observe
examine
that.
Tahir Ali. I have not gone through the judgment.
No, not Tahir Ali.
I don't know. This is what.
Not Tahir Ali. It is a gazetted notification.
I'll go through it.
Whereby the circle officer, deputy commissioner for the purpose of settlement rules includes circle officer.
I'll go through.
That is gazetted.
I'll go through it.
Amendment was made.
Amendment.
I'll go.
Amendment made on, my lord, 6 to 2000.
That I am not observing that.
Yes, yes.
That is a legal issue. You keep it for the next round. Heard Mr. P. K. Roy and Senior Counsel, Assistant Commissioner R.J. Das, Learned Counsel for the petition. And Mr. R. Borpujari, Learned Standing Counsel Revenue.
For respondent number 3, my lord.
And Disaster Management Department for the respondent number 3. Yes, Mr. Goswami, your submission is similar lines. And Mr. N. Goswami, Learned Junior Government Advocate Assam for the respondent number 1, 2, 4, 5, 6, 7, and 8. In view of the issue involved, which is only a legal issue. And as agreed by the learned counsel for the parties, the writ petition is taken up. The writ petition is instituted under Article 58 of the Constitution is taken up for final consideration and the motion stays itself. Full stop. It is better. The petitioner has asserted that he is in continuous occupancy of a plot of land measuring 1 katha, 5 lessers, covered by Tozy number 388 and DAG number 305, situated at village Numoli Jala, Moza, Hinduri Gopa, Police Station, Sangsari, District, Kamrup, Rural. Subject or sort. There was litigations earlier in the form of 2 writ petitions, WPC number. This MC page 26 is arising out of what? Page 26 is MC.
4033/2014.
4033/2014. And WPC number 3187 2021. Full stop. There was a miscellaneous. There was also a miscellaneous proceedings in the form of miscase number 2490/2014, which arose out of the writ petition from a WPC number 4033/2014. Software. The is in continuous occupation of the so-and-so since 1982. Since 1980. The petitioner has stated that he and his family has been living in the subject plot by constructing sheds, etc. their own. When in the year 2014, action was initiated to evict the petitioner from the subject plot, the writ petition, WPC number 4033/2014 was initiated and in miscase number 82490 2014 arising therefrom was disposed of by an order dated 18/4/2019 with the following observation. Page 28, paragraph 6, paragraph 7. When the respondent authorities initiated another process of eviction in the year 2021 by serving a notice dated 21/6/2021 the petitioner aggrieved thereby, instituted the second writ petition, WBC number 3187/2021. By an interim order dated 29/6/2021, interim protection was granted to the petitioner to the following effect. Page 31, A, 2, A. The writ petition WBC number was 3187/2021 was disposed of finally by an order dated 28/8/2023. Post of the relevant excerpts of the order dated 28/8/2023 read as under page 49. B to B, paragraph 6. Full stop. It is in the backdrop of above fact situation, the petitioner has laid challenge, through the present writ petition, to two notices. One, a notice dated 28/11/2023 issued by the Chief Executive Officer, Guwahati Biotech Park, Guwahati, whereby the petitioner was requested to furnish valid documents in support of the plot of land under his occupation with the further observation that in the event of his failure, the petitioner should vacate the place, vacate the plot of land. And a notice dated 20/12/2023 issued by the Circle Officer, Guwahati Revenue Circle, Kamrup, whereby the petitioner has been asked to vacate the subject plot on the ground that the subject plot has already been allotted in favor of Guwahati Biotech Park, and the petition is found to be in unauthorized occupation of the subject plot. Though a number of contentions have been advanced on behalf of the petitioner, what strikes is that what strikes to the court is that the order, the direction made by this court in the order dated 18/2/2019, quoted above, is in operation till date, and the respondent authorities, it is also the learned counsel appearing for the respondents have fairly submitted that the respondent authorities are obligated to issue a notice under Rule 18(3) of the settlement rules framed under the Assam Land and Revenue Regulation 1886 as amended. Rule 18(3) of the settlement rules read as under. We could do 18(3). It is the considered opinion of the court that it is an admitted position that the petitioner is in occupation of a government house land. Full stop. Under the settlement rules framed under Assam Land and Revenue Regulation 1886, no authority is found vested in an authority like the Chief Executive Officer, Guwahati Biotech Park, to ask a person in occupation of government land, even if such occupation is unauthorized occupation, to vacate from a government house land, from government house land. Full stop. In such view of the matter, the impugned notice dated 28/11/2023 issued by the Chief Executive Officer, Guwahati Biotech Park, Guwahati, is found to be lacking in jurisdiction. Insofar as The notice dated 20/12/2023 issued by the cycle officer, Guwahati Revenue Cycle, is concerned, comma, it is noticed that only 3 days time period has been given to the noticee, that is the petitioner, to vacate from the to vacate from the subject lot. The learned counsel for the respondents have submitted that, have fairly submitted that the impugned notice dated 20/12/2023 is neither in conformity with the direction made in the order dated 18/2/2019 passed in Miss Case number 2490/2014, arising out of WBC number 4033/2014 and the order dated 28/8/2023 passed in WBC number 3187/2021, nor in conformity with the provisions contained in Rule 18(3) of the Settlement Rules framed under the Assam Land and Revenue Regulations 1886 as amended. And to stop. In view of such submission, as the impugned notice dated 20/12/2023 issued by the cycle officer, Guwahati Revenue Cycle, is found not in conformity with the same repeat koridibo and the provisions of rule order miscase koridibo and provisions of rule 18(3) of the settlement rule so and so, the impugned notice dated so and so is set aside and passed. Is hereby set aside and passed. The respondent authorities, while setting aside the impugned notice, it is observed that the respondent authorities will be at liberty to proceed strictly in terms of the direction made in so and so and made in so and so and Rule 18(3) of the settlement rules framed under so and so.
Deeply obliged.
Anything to be added?
No, my lord, yes. Wholesome order.
Item number 36.
I'm obliged.
Yes.
May I please, your lord? Well, the matter relates to the customs department. What happened? Petitioners were traveling from Agartala to New Delhi, and my lord, husband, wife, they were intercepted by customs people at Guwahati railway station and platform number 4 on 19/9/2023 and taken away our 2 mobile phone as well as our necklace that we are wearing.
Very weighty.
Yes, my lord. Yes, but it is their custom.
If it is necklace,
Yeah.
and this entire amount,
14 lakhs value.
entire weight, 235 grams.
Yes, and value is
235 grams.
14 lakhs, 19,000, 91.
That is a necklace only.
Necklace, 2 necklace.
One
My lord,
necklace.
2 necklace, husband, wife. My
So
lord,
what is the prayer here?
prayer is the, my lord, we have been to the Shillong office, directorate, my lord, for adjudication of the matter. They said, unless Guwahati office, that is deputy commissioner, is sent the forward your application, that we cannot take up. That accordingly, my lord, we have approached to the annexure 2 to the Guwahati unit of the Directorate of Revenue Intelligence, page 20, my lord, kindly, to forward our application to the Shillong office. But still today they are not doing it.
So basically, seeking a direction
Yes,
to the respondent custom
yes,
authorities.
yes, yes.
to
So that we
make,
can apply our
to take
application.
immediate steps for to dispose of the application 19
Exactly,
and
exactly.
to forward the matter for adjudication before the additional so-and-so.
Additional oblique joint director customs prevent.
Shillong. There is a
Shillong.
prayer.
Shillong.
Lordship, we have received copy today. Allow us time to obtain instruction from department.
Shall we issue notice?
Yes, Lordship.
Maybe, madam.
Heard, Mr. S.C. Bishop, Learned Counsel for the petitioners, side of the petitioners, and MS.
M. Deca.
You are for
Lordship, respondent number.
All
2 by
respondents,
3.
madam, all
all,
respondents.
maybe may not be. Any CGC?
Yes, Lordship.
You are CGC?
Yes, Lordship.
From 1 to
Lordship. all
From 1
respondents.
to 6, madam.
all?
Yes,
Yes,
yes. all.
Lordship.
You are Central Government Council?
Yes, Lordship.
The customs department.
Custom department. Custom.
You are custom?
Yes, Lord.
MS?
M. Deca.
M. Deka, like Central Government Council.
On behalf of SCKL.
On which,
Oh.
SC Kyle, madam.
Right. Whether he can take instruction for 1 also? Okay. Learned Standing Council, customs.
Yeah, custom, madam.
For all the respondents.
Yes.
Full stop. It is the case of the petitioner that when the petitioners were traveling by Agartala Anand Bihar Terminal Tejas Rajdhani Express on 19/9/2023, two numbers of gold chains of identical size, weighing 235.960 in total, were seized by the respondent
Number 6,
by the
madam.
officials
Yes,
of the respondent custom department.
yes, yes.
Full stop. Seeking directions inter alia to the respondent custom department, respondent authorities in the custom department to take any immediate steps to dispose of the application dated 9/10/2023, submitted by the petitioners, and to forward the matter for adjudication under section 110 of the Customs Act 1962 to the
That's number 4.
additional stroke Joint Commissioner of Customs within bracket preventive, Northeast region, Shillong. Immediately, the instant repetition has been prepared. As MS Deca, Learned Counsel appearing for the respondent authorities has sought time to obtain instructions in a matter. Issue notice returnable on 24.
But little earlier.
1. No, earlier hardly very few days. View vacation also.
Any, by 10th, my lord, possible 10/1.
10/1.
Lordship, any date, Lordship.
Any
After
date.
vacation.
My friend is agreeable.
10/1.
10. Develop.
As so-and-so, no formal notice. Extra copies during the course of the day.
I've given, I would like given.
Yes, only be able to do it. No, otherwise, we will postpone.
I'll
it.
give. I've given her, I'll give again.
Much obliged.
Time being item number 25.
I got the amendment copy type. So I'm going to file my today, my lord.
Yes. What is the case?
Case is that, my lord, the AGM was held on 24/9/23, my lord. And the earlier body is to expire on within 30/9/2023. They are to complete the election, my lord. Now, in this way or that way, election could not be held due to sort of quorum, my lord. So that proceeding, the day on election, the proceeding has been cancelled by the chairman, my lord. And thereafter, the Assistant Registrar of Cooperative Society has passed the impugn order. There is page 34, Annex 7. Relevant part is on 35. From second paragraph, under the above circumstances, I, Dr. Nasiruddin Ahmed, Assistant Registrar of Cooperative Societies and Election Authority in purview of section.
Yes.
Section 39 of Assam Cooperative Act 2007, do hereby dissolve the Board of Directors of Sunari Guard GPSS Limited. However, the Board of Directors did arrange the AGM election in due time, but could not complete the procedure within the month of September due to incompetence and malafide intention of the secretary. Hence, the board members cannot be termed disqualified. The returning officer is hereby directed to keep the nomination dated 49/23 intact, including the nomination of incumbent board members, if any. Further, a proposal for appointment of executive officer to manage the affairs of the said society under section 3 will be forwarded to Junior Joint Registered Society, Silchar. However, after appointment of executive officer, he is allowed to conduct AGM election afresh, and further nomination from shareholders of the society can be invited. However, the already accepted nominated members shall not file nor shall not apply again, as their nomination will be kept intact under the above circumstances. This part we have challenged, that nominations are no more valid. The persons who were failed to conduct the AGM, my lord. The law is that
We need to say they are disqualified or non-qualified. It is for the returning officer to decide about the nomination papers.
My lord,
Who is he?
my lord, I am for the caveators, my lord.
Right.
My lord, my learned friend should, my lord, disclose the facts, my lord, before the half part of the impugn order, my lord. The impugn order itself, my lord, if the whole is read, my lord, what was the facts, my lord, what was the circumstances, my lord? So may I pray for, my lord, reading the whole part, my lord. The observer of the election, my lord, reported, my lord, what happened on that day, my lord. The observer report is, I think, is not annexed, my lord. Observer report is there, my lord. It is not annexed. So, my lord, in the impugned order, 3rd of October of Assistant Registrar, my lord, may I read, my lord? And my lord, I have not the copy of
If
the.
something is closed that could not be held, AGM and election, how can you retain all this?
My lord,
Tell me.
My lord.
Yes, Mr. Standing Counsel,
May I read-
Corporation.
my lord, may I read
How
for a-
this is sustainable? You'll be given opportunity. First day, Mr. Standing Counsel has the right of audience. Yes, how this is sustainable?
Lordship, what has happened, your lordship, that the resolution was.
What
not
has
for the
happened is
election.
that AGM was convent,
Yes.
election was convent.
Yes.
That could not be held and time period lapsed.
Lordship.
So body dissolved,
Lordship,
right?
lordship.
One-man committee appointed.
Yes, your lordship.
He has been asked to conduct election and AGM.
Lordship.
So it is a new process under new authority.
Lordship, Lord. Only one aspect which is there, because if it's a new process, your lordship, then the election could not be held, the AGM could not be held, it was not because of the fault of the board of directors, your lordship. The board of directors, through a proper resolution, has called for AGM election.
Whatever.
And so, your lordship, he has,
God
if your
dissolved.
lordship comes to the first page 34, your lordship, of the order, the grounds.
Whatever, lack
mentioned,
of
your
quorum.
lordship.
Lack of quorum.
Lordship, first para, your lordship, perused the observer report dated 28/9/2023 and found that it was on the part of the incompetence of the secretary that he failed to issue share.
In this way, old wine cannot be, you should not be allowed to put old wine in a new bottle.
Lordship. So, your lordship, the question here, your lordship, is whether it is because of the fault of the secretary and the returning officer.
Well
your lordship.
examined, but this kind of observation is not correct. Prima facie. New election and new nomination.
Then
why he is assuming jurisdiction, this returning officer also?
Lordship.
What authority this observer has under the act? He is merely an observer.
Yes.
He cannot decide about nomination papers.
Lordship.
He has no authority and jurisdiction under 2007 Act.
Yes.
He is merely sent by the register
Yes.
to observe and report whether regularly done or not regularly done.
Lordship.
He has no legal power here. Is there any power vested under the rules? 2019 rules?
If the election rules are there, Your Lordship, 2019.
Is any power vested? And who is he? Page 35, unless so and so. Purview of so and so dissolved.
And my lord,
Could not complete the procedure. Hence, board members cannot be termed. Yes, Mr. Cooperative.
my lord.
And who are you?
We are the members, my lord. Members of the society, my lord.
Did you submit your nomination paper at that earlier time?
No, no, my lord. Because if we submit nomination, then we will be disqualified, my lord, for coming election, my lord. That is the law, my lord. Yeah, once the director.
Now, from
Yes, that is the.
from a few days back now, this ground is hesitated now.
My lord.
Yesterday also? Yes.
My lord, actually, my lord, though they are the petitioners, the whole story is, my lord, made by the chairman, my lord, earlier chairman, my lord.
Oh, no, we will go by the papers. Who is?
Yes, my lord, it is mentioned in the.
Who is?
It is mentioned in the.
Manufacturing what we are not.
My lord,
We are with the observation page 35.
Yes, it is mentioned, my lord, in the report of the observer, my lord. In the report of the observer, my lord, that the chairman, my lord, did not allow, my lord, the persons, my lord, all the requisite, my lord, the quorum was present, my lord. It is mentioned in the order, impugned order. May I read, my lord? That 3rd of October.
Page 34.
3rd of October, my lord.
3rd of October, 1, 2, 3, 4, 5, 6, 7, 7 line. Cancelled due to lack of quorum.
Yes, my lord. But my lord, the from second paragraph, may I read, my lord? From second paragraph, peruse the observer reported so and found that it was on the part of the incompetent secretary that failed to issue share card to the shareholders. All the quorum was present, my lord, on that day before the AGM as identity proof required at the time of the signature.
Have you challenged this that quorum was present? So I challenge this. No, that is not the case.
My lord.
That is not your case.
Not my lord.
Have you challenged this?
This is the case of
Lack of quorum. Have you challenged this?
No, my lord.
That we should not have been, that proceeding should not have been adjourned or cancelled or whatever on the ground of lack of quorum. Because this authority has already observed that lack of quorum.
But my lord, the report was there that the quorum was present, my lord. The report was there.
That is why I asked Mr. Raskwa whether this authority has, observer has the authority.
He, my lord, submitted the report, my lord.
He submitted a
Report, my lord. I have a report copy of the report, my lord. Your lordship, may my lord. May I submit, my lord, a copy
Tell
of the
me this page 35, second para. Who is he to decide about the nomination papers?
My lord.
Who is he?
Observer did not.
No, this existing register.
ARCS, my lord.
ARCS,
Yes, my lord. ARCS,
Who
my
is
lord.
he?
On the.
Nomination papers
Yes.
are only after declaration of election. The election is to be notified. Only thereafter nomination papers are to be submitted.
Already.
And the returning officer appointed after the along with the notification or after the notification will decide about the nomination papers. Earlier returning officer declaring nomination paper valid will not, that decision will not get transferred for the next returning officer.
Yes, my lord. May I submit, my lord, this kindly.
No, I'm not satisfied.
Report, my lord.
Whatever be.
Observer's
Report,
report, my
I'm not looking at.
My lord, may I submit that, my lord?
That new process, new beginning.
The report says that, mark.
New nomination papers.
The quorum was present, my lord. But
When,
the chairman and secretary, my lord.
that I'm not accepting Mr. on the basis of Mr. Quadi's submission.
It is, it is mentioned in the, my lord, impugn order, my lord, itself, my lord. That the Kunam was present, but they were deprived to sign them.
Okay, you submit your response.
The procedure is there in Rule 23, Your Lordship. If it's adjournment of poll, it's under Rule 19, Your Lordship. And for re-election, Rule 23.
Nomination will remain valid.
Not.
So this is the question to be tested.
Yes, there is.
Adjournment time is over, my lord.
Third, Krishna, Learned Counsel for the petitioner. Mr. B. Rajpal, Learned Standing Counsel, Cooperation Department. For the respondent number 1, 2, 3, 4.
5 also. my
What
lord.
is 5?
5 managing this one-man committee.
5.
Well, I
Mr.
for
Quadri,
9, well, 9, 10, 11.
he is not submitting anything.
My lord,
Very
that is-
difficult.
Money it is there, my lord. Just for my lord, your.
No, no, I cannot.
Your-
8, 9, 10, my lord.
Only for this day, I am condoning it. Which I. Respond number?
My lord, 8, 9, 10, 11.
8, 9, 10, 11.
15, 16, and 17.
Comma, who has been implemented by order dated 19/12/2023, passed in IA Civil 3829, 2020. The subject matter in this petition pertains to annual general meeting stroke election to the two Messrs. Sunabori Ghat Cooperative Society Limited, a society registered under the provisions of the Cooperative Society Act 2007. The two petitioners have claimed that they are the shareholders. They are shareholders of the society. The case projected in this writ petition, can be in brief stated as follows. The earlier board of directors of the society convened the AGM election on 24/9/2023. And as per the order dated 3/10/2023, a part of which has been impugned herein, of the respondent number 4, the AGM stroke election convened on 24/9/2023 had to be cancelled due to lack of quorum. Full stop. That the AGM stroke election comma, convened on 24/9/2023, comma, had to be cancelled. Is also substantiated from the report dated 27/9/2023 of the returning officer appointed for the said AGM stroke election. Full stop. While observing, so as the AGM stroke election of the society could not be held within the prescribed time period, prescribed by the 2007 Act, comma, the respondent number 4 by the order dated 3/10/2023 had dissolved the board of directors of the society, previous board of directors of the society, exercising power under section 39 of the
41.
39 read with section 41 within bracket 6 of the 2007 Act. Full stop. Pursuant to the order dated 3/10/2023 of the respondent number 4, comma, the respondent number 3 by order dated 5/10/2023 has appointed an officer of the Corporation Department, appointed one senior inspector stroke auditor of Cooperative Society as officer on management to manage the affairs of the society and also to hold the AGM stroke election of the society within 90 days and to constitute a new board of directors of the society as per the provisions of the 2007 Act. But it is in that it is in the apposite backdrop of events, comma, that part of the order dated 3/10/2023 of the respondent number 4 has been challenged, whereby the respondent number wherein the respondent number 4 has held that as the the members of the directors in the previous board of directors of the society cannot be termed as disqualified, and it has been further directed that the returning officer, it has been further directed to the returning officer to keep the nomination papers of the directors of the previous board of directors intact. Full stop. Firstly, Mr. Sinha, learned counsel for the petitioner, has assailed that part of the impugn order on a number of grounds, comma, firstly, comma, the returning officer for the next AGM stroke election has not yet been appointed. Was not appointed at the time of passing the impugn order on 3/10/2023. Secondly, once the process of AGM stroke election stood cancelled, there cannot be any direction to retain the nomination papers submitted in connection with the said AGM, said election to the board of directors of a society. Thirdly, the respondent of does not have the authority and jurisdiction to decide on the matter of qualification or disqualification of any nomination papers, as it is the prerogative of the returning officer appointed for the purpose. Issue notice returnable.
My lord, may I mention that, my lord, already, my lord, returning officer appointed and election date is fixed, my lord.
Was. I said was. I said was.
Yes.
Not.
But subsequent returning officer already, my lord, fixed the election date. We should notice, my lord.
Issue notice returnable on so and so. As Mr. Raspa and Wadi. Baki Nobogira Skylovo, the petitioner shall take steps for service of office. Upon the respondent was so and so by restart post detail. We need 2 working days. Having regard to the events narrated above briefly and considering the submissions of the land support of petitioners, this court is of a considered view that the petitioners have made out a prima facie case for interim relief. Accordingly, that part of the impugn order dated so of the husband of court whereby a decision was made as regards eligibility, as regards qualification of the board of directors, as regards the directors of the directors in the previous board of directors of the society, stood dissolved by the order dated 3/10/2023 and keeping and the decision regarding retaining the nomination papers dated 14/9/2023 for the purpose of further consideration or for the next election of the society shall remain suspended.
Extra copies may be started.
Hello, sir. Obliged.
Time being item number 32.
My lord, in this case, as asked for by this honorable court, my lord, instruction in the receipt, my lord. In fact, notice was served to, my lord, the April itself, my lord. So not that notice was not served, my lord. Number one. Second thing is, my lord, the alignment cannot be changed, my lord, because of 9.5 lessons of land, my lord. And the requisition is made because, my lord, under the Act of 1964, because of the urgency, my lord. And so for
Access land what?
and no access land has been acquired.
copy. Copy.
আছে, everybody.
The question that was asked yesterday, whether any order was passed.
My lord. Order.
Serving of notice is one thing.
My lord.
Within 15 days, the landowner has the right to submit a representation.
Then after A notice, then B notice they will get B notice, my lord.
Where are those?
My lord, certainly that will do. So if they have anything to say, my lord, with regard to their compensation, ample opportunity they will get, my lord.
Right.
The next stage is only for my
No,
lord.
otherwise, an act which is statutorily required to be done has to be done in that way or not.
My lord,
In other way.
my lord. Only thing they can say.
You have, that is yours, the statute governs everybody in equal manner.
My lord, yes, and no one has objected to, my lord. Not only the particular plot of land, my lord.
No, objection is not, I have asked that what is required to be followed.
Yes.
Must be followed.
Yes, certainly, my lord.
And
Certainly.
where is that?
That, my lord, tomorrow, yesterday, matter was taken up, my lord. Within a, my lord, span of day, my lord, that everything cannot be obtained, my lord. That is why, my lord, at the first instance, which we can submit before this honorable court.
Because this is Form A.
My lord, yes.
Notice and order.
My lord.
And
And thereafter,
admittedly, 15 days representation was submitted.
my lord.
And thereafter, on the basis of that,
My lord,
rejecting, allowing, that is a different
My
matter.
lord.
Ought to have been done. That is the question that
That is why, my lord, we'll get everything, my lord, on reopening, my lord, including the record, my lord. Lordship will fix a date on the 5th or 6th of January, my lord. We'll obtain the record, my lord. At least we can produce the record, whether authority has followed, my lord.
okay, get the records. But in the meantime, while processing, do the survey.
My lord.
We are not stopping it. Do the survey.
My lord, yes, yes.
Suspend of damage.
Yes, yes.
My lord, it's in the middle of the plot of land. So the either side of the
Right, whether as a consequence, your entire plot is required to be assessed for compensation, that can be examined not at this stage.
Yes.
Look, I'm not objecting to the
And
construction.
there is otherwise legally no bar.
And that is why I am not objecting to
Legally
the
no
construction.
bar,
I am
one can
what
have,
I'm-
but at least the that aspect ought to have been looked into.
My lord, I'm not objecting to any
On the other
requisition
hand,
process.
that is also an infrastructure project.
Yes, my lord. Definitely, I'm not
All
objecting.
this
The only
project
thing
was-
is, I am requesting they may construct it on the backside of the plot of land.
That alignment cannot be.
that is a which is to be examined only after getting the record.
My lord, the Form B that has not been
But
issued.
that issue cannot be decided, my lord.
That issue cannot be decided as of today.
My lord, the rule says so. Rule 4 says so.
The
Before we
alignment, so far alignment is concerned, my lord, rule does not say
of this
anything.
rule of 1964 is says an order of requisition under section 3(1) shall be in Form B as far as maybe with such modifications, if any, as may be necessary. So for a requisition also, a Form B order has to be passed.
Right, that is what I am asking.
Yes.
That whether Form B order has been passed or not.
Yes.
But so far as your claim that it should not go in the middle of the
Yes, that cannot be.
plot of land, otherwise there is no legal bar as such. But the consequence that would emanate that as a result that line would be or the tower would be installed in the middle of the road, as a consequence your entire plot would be damaged.
Yes.
And cannot be utilized for any gainful purpose. That issue we cannot decide as on.
My lord,
right.
But
that consequence will come later on.
That irregularity of non-disposal of representation file and the notice for hearing was issued in the month of December, page 55. Lordship.
You make the assessment survey and place it before
Either 6 or 7 January, my lord, 2024.
7 holidays.
I think, my lord.
6 Saturday, Sunday.
Then 8, my lord. We'll produce the record, entire record, my lord. Lordship will decide.
Okay, you produce that.
Can it be on 9th, my lord?
8, if required, will spill over to 9th.
Yes. course.
Heard. Mr. Adhor, learned counsel for the petitioner. For the side. Maybe of Mr. B. Kusami, learned additional advocate in Assam. It is stated by Mr. A. Bhattacharya, learned standing counsel revenue. 1. S. Borua, junior government advocate Assam for the number 2. Mr. Goswami, learned additional advocate general, has placed a communication number so and so dated 2012-2022 from the additional deputy commissioner Kangu. Post up. It has been stated in the said communication that the respondent authorities are not utilizing more than 9.5 lassa as mentioned in Form A notice. Full stop. Mr. Dot as the counsel for the petitioners has seriously disputed such fact. Full stop. The state respondents has not placed any copy of the order required to be passed under Rule 4 of the Assam Land Land Requisition and Acquisition Rules 1964 on the basis of a representation received from the landowner in Form A. Mr. Goswami, additional advocate, has submitted that he will produce the records, preliminary records as regards issuance of any order under Rule 4 on the next date of listing. Release the case on 5. 5?
5th January.
Or 8.
5th, according to him, 9th.
Or 5th.
8th.
My lord, just one thing. In the meantime, this order may not be a bar for disposing of my representation because hearing was
okay. Or you describe this.
My lord, your lordship will hear the matter on 8th, my lord.
There is no bar. You can additional advocate general. You can ask this authority.
That is the authority.
In the
It is not there. Again, because of this, my lord, issue can be.
If the representation submitted by the petitioners in response to Form A. Resolution dated 2/6/2022 in bracket annexer type to the ratification has not yet been disposed of by the respondent authorities, by the competent authority, comma, the same. There is no bar to dispose of the said representation by the competent authority. No, the respondent authority, the competent authority is at liberty to dispose of the said representation on or before the next date of listing.
My lord, last page, my lord, page 55, annexer 7, my lord. He was asked to appear before the additional district commissioner, my lord, fixing 16/12/2023, my lord. But he has not explained, my lord, thereafter what happened.
he has said, I have made statement. They appeared on 18th. 18th
Appeared.
last hearing was on 18th.
18th.
18th of December.
Which is there.
Nothing was there. My lord, lordship was indicating some survey regarding.
No, that will on 8, lordship will consider.
Records, we'll see the records. That is why.
Oblige.
Oblige.
Find out if in the middle of the road,
In the-
something is installed as a result, entire plot of land
Yes.
gets diminished in value, what would be the consequence?
Oblige.
Find out.
Definitely.
State can acquire.
That
Only
we are
thing
not
is
also
that-
objective.
That is why, my lord, 1964 Act.
Monetarily, you should not be.
Yes.
And the
deprived.
interesting part is that both sides of the land, these are government lands.
I understood.
Production list item number 1 for motion.
Yes.
Lots of the petitioner is is a stamp vendor, lots of operating within the campus of District Commissioner Guwahati, lots of. His license was issued in the year 2006. Initially, the area of operation was campus of Lawyers Association Guwahati, and thereafter on 19/4/2007, it was shifted to DC Port campus. Lots. It is reflected at page 17, lots, Annex 1. Annex 1, page 17.
That was in premises of deputy commissioner or what?
District Commissioner, Deputy Commissioner, DC.
That is DC court.
Yes, yes. That means
Complex. That court complex is not there.
It has been shifted to Hangrabari now. So the entire vendor were also shifted there. They were given certain accommodations lots. So that were being continued lots of. And in terms of the condition, they were operating within the campus of DC office lots of. So now, yesterday lots of, without there being any reason lots of, the person number 3 has called the petitioner and along with other vendors saying that they would be evicted from that place lots of, indicating something from the office of the chief minister lots of. That's why the petitioner is before you lots. I've annexed the photograph of the vending outlet of the petitioner lots.
No, how you have constructed this?
No, Lordship, they have, with the permission of the Deputy Commissioner, District Commissioner, they have permitted, and electricity connection has been given free of cost from the office. Other facilities were given, Lordship. Now the e-stamping, where the vendor particular petitioner is issuing the e-stamp, Lordship. And in terms of the license, he is operating within the campus.
No, where you have stated what is that?
Lordship.
Where you have stated that what transferred yesterday or?
Oh, Lordship. Lordship, I have stated in paragraph 5, Lordship.
Hmm?
Paragraph 5, Lordship. Page 9, Lordship.
Yes, Mr. Goswami.
Yes, my lord, over phone, my lord, we have been told this is steps with regard to, my lord, broker-free DC office, my lord. Because, my lord, his room has been,
That is a welcome step.
yes, his room has been, has become a, my lord, addathuli of brokers. That is,
You catch hold of all this.
my lord. That
It
is
is
the,
over. That is a welcome step.
my lord.
You want to free
All
the
the
offices
my lord.
out of all these touts and all these
Yes.
brokers.
Touts are dear brokers.
But
touts.
here he is a stamp vendor.
My lord, that is the room, my lord, allotted in.
Right. Some activities are going on.
That has been informed, my lord.
That has been informed. So
And license is renewed up to 31st March.
that is a bit harsh.
My lord.
That is a bit harsh. Maybe he may be involved in such activities. That is a different matter. Otherwise, removing him from that place is one thing.
No,
Catching hold of him doing such
no,
activities
he
is one
can
thing.
do his business even outside the
No,
DC office. No
no,
problem for that.
No, it is not that he has gone there on his own and became an encroacher. I think it was with the knowledge.
Yes, he applied the government allotted.
And
my
just
lord.
with the knowledge,
My lord.
suddenly you'll say
That is why, my lord, as per the information received, my lord.
Bona fide persons definitely can go there to buy stamps.
Yes.
You try to move out all these
Experience says, my lord, these are the
dubious
centers.
persons.
These are the centers, my lord.
Experience is right, but there's not that does not that mean that you affect the livelihood.
No, they can do that. Their business even outside DC office, no problem. for
Okay,
them.
give the space.
But
Yes.
space,
You
difficult.
give the space.
My lord, in all cases, state cannot
We'll,
provide.
we'll keep it in the motion. Or don't take any coercive step
My,
till the next day.
my,
Heard. We'll go into it.
No, sir.
Heard, Mr. Didas, Learning Council for the petition. Sudden eviction is very difficult for Mr. B. Goswami, learned additional advocate, General, Assam, assisted by Mr. R. Borpujari, learned standing council revenue, Quarter number 1, and Goswami, additional junior government advocate Assam, Quarter number 2 and 3. In this, the petitioner has claimed that he is a licensed stamp vendor.
No, sir.
And he is operating his business as such stamp vendor from and within the campus of the office of the Deputy Commissioner, Kamrup Metro. Post office. It has been averred that on (21/12/2023), the respondent number 3 called the petitioner and asked to remove the belongings of the petitioner from the space allotted to the petitioner earlier, outside the office premises of the Deputy Commissioner.
Within the campus.
Huh?
Within the campus. Within the campus.
This
within the campus.
Within the campus.
okay.
According to
To relocate his belongings from the space earlier allotted to him, to another place within the campus.
No, no, Lord. I'm probably I'm not able to communicate. This vending outlets is within the campus, Lord.
That was what I dictated.
I'm sorry, Lord.
That go outside the campus.
Yes, Lord. I'm sorry.
I go to Gambasi. As Mr. Goswami, well, it is his submission that such demand to relocate will be to the immense prejudice of the petitioner. Also, as Mr. Goswami, learned traditional advocate general, has sought some time to obtain instructions in a matter, including the instruction regarding relocation of the petitioner from the present place to any other appropriate place, lays the case on 8-1 or 5-1.
Since some interim protection lordship has given, few days later.
Okay, then we'll issue notice.
Then it, lordship.
Okay. Let notice be issued, returnable on 22/1/2024. As Borpujari and Goswami accepted notice, no formal notice. You serve them today, during the course of the day, no formal notice, having regard to the projections made by the petitioner. by making such statement on oath, comma, it is observed that till the next date of listing, the status quo as regards the location of the petitioner, location of the stall, wherefrom the petitioner is operating as thumb vendor shall be maintained as within bracket as indicated in annexure 2 photograph
24, my lord.
24. That paragraph annexure 2 photograph
Right.
he is showing that only and restrain all the brokers.
Right.
Not
It's
only,
it's a public office. That is why, my lord, difficult to restrain all at the threshold.
not, Lordship, then not only the petitioner, all the vendors were called yesterday. Lordship.
Production list item number 2.
I'm deeply agree.
This is an eviction matter, my lord. This land actually, my lord, belonged to the petitioner, then it was acquired in 1960s, my lord, for the purpose of road, my lord. Now, my lord, this present notice has been issued, my lord. Lord, it shows that, my lord, that
You are what? You are landowner or
actually, well, this land belonged to us, and but later on,
belong to us is
Yeah.
one thing.
yes, my lord, it was acquired thereafter by the PWD, my lord.
Huh?
Now it's a government land, my lord. I mean, we are,
Government land.
it was acquired by the PWD, my lord. It was our land, it was acquired by the PWD. Now, my lord, this land, my lord, were for the purpose of the road, my lord, was to be acquired for the purpose of the road. Now, what has happened, my lord, since it was, the road was widened, and some part of it remained, my lord, without being used, my lord, for the road. So we are using those land, my lord. Now the problem, my lord, this notice has been issued. my lord.
Acquired land.
Acquired.
You were using.
Yes, ma'am. Yes, ma'am, that's
That is the case.
that is the case, my lord. But what has happened here, my lord? This notice has been issued.
With the acquisition, land stands absolutely vested
Yes,
with the state.
That's right. That's right. No problem with that. That is not in dispute. We are not disputing that. my lord. What has happened here, my lord? Lordship will see the notice, my lord. Now, this notice says the land is for the purpose of, my lord, the Kalapani police outpost, my lord. Now, Kalapani police outpost is about 500 meter, half kilometer away, my lord. We made a specific statement,
Whatever be the ground.
my lord.
Whatever be the ground.
My lord. So, my lord, our case is, my lord, once, my lord, if it is into the road is, my lord, extended, we don't have an issue, my lord. One, my lord. Secondly, my
You
lord,
are not in a position to agitate those issues.
my lord, what I'm submitting, my lord. One, my lord, is that if any constructions come up, my lord, our patta land, which are just behind the road, my lord, which is there, still there, my lord, those will become, my lord, landlocked, my lord. There will be no, my lord, ingress and egress, my lord, possible, my lord. Those will be so totally obstructed. If the road is,
You are saying on one side that road is being widened.
yeah, no, road was already widened, my lord.
Huh.
There are some land remain, my lord. So now we have access from the road, my lord, through this land, my lord. That's the reason, my lord. Just so this is, my lord, not a very, my lord.
Pedokhol Mukto is cannot be state.
Not, my lord, not, my lord.
That cannot be state.
My lord,
That issue that ingress and egress it will be examined. But so far
that is one aspect. Another
already acquired land.
my lord. That's true, my lord. That we have stated, my lord. We cannot deny that.
Absolutely stands vested
Yes, ma'am.
with the government.
Yes, ma'am. That's true, my lord. That's true, my lord. But it was allotted for the
And
purpose of road.
whatever purpose
My lord.
they would be using it.
My
It is their prerogative.
True, my lord.
You cannot
But
have any
since
say
it
over
was acquired for the purpose of the road, my lord, if the road is extended, well, we cannot have any say. my lord.
issuing notice here.
My lord, only thing, my lord, is that the 7 days time again, my lord, we have to, my lord, remove our belongings also, my lord. That is also too short, my lord. As per the, my lord, act, my lord, at least 15 days time is, my lord, can be given, my lord.
You give the undertaking? Give the undertaking before the court
My lord.
that you on your own
My lord.
will vacate this 2 bigger plot of land.
My lord. Well, only thing they will look into this
subject to that ingress and egress
that
will be looked into.
Well, because if any construction building comes from, then our land will totally be locked, my lord. That's a
Building cannot be within 15 days.
no, it can be within 50 days. I'm saying, but that's what I'm saying.
But if this will record that,
My
that
lord.
ingress and egress to petitioner's
Yes.
land will be affected.
Yes, my lord. That is
Which issue will be examined
Yes,
in
my
a later stage of the case.
my lord.
Right?
My lord.
Okay, we'll issue notice at this.
That will protect us, my lord.
Heard Mr. M. Dotto, learned counsel for the petitioner, and Mr. B. Goswami, learned additional advocate general, Assam, assisted by Mr. R. Borpurjai, Standing Counsel, Revenue for 1. CVNA PWD, M. Das, Standing Counsel PWD for respondent number 2. Junior Government N. Goswami, Junior Government Advocate Assam for the respondent number 3, 4, and 5. Who is this? 7 and 6.
7, 8, well, we say that these are done at the behest of these persons. Well,
Huh?
these are done at the behest of these persons. That's the allegation. Well, of course, but I'm that's why I'm not. Well,
Hard.
this may be issued. Well,
Full stop. It is a case of the petitioner that the petitioners are owners of Pata lands at village Thorakhua, Mankasar Revenue Cycle. Full stop. In addition, it has been stated that in addition to their periodic Pata lands, the petitioners are also utilizing some wastelands.
yes, sir. By the side of the road, my lord.
By the side of their Pata lands.
Which was
For
acquired
the
from them.
purpose of ingress and egress to the petitioners' Pata lands. Full stop. The petitioners are aggrieved by the service of a notice dated 18/12/2023, whereby the petitioners have been asked to vacate a plot of land measuring 2 bighas covered by government DAG number 17/12 at village Sidakhwa. Full stop. Well, Mr. Okay, I am not putting this in your mouth. Mr. Goswami, Additional Advocate General Assam, has submitted that the lands which the petitioners have been using have already been acquired by the government long back, meaning thereby with the acquisition, those lands stood absolutely vested with the state. It is the prerogative of the state to utilize such lands in the at its discretion, and 2 bighas of such land is required for the public purpose of establishing a police outpost, and as such, the petitioners have no vested right to continue in occupation of those lands. The matter regarding ingress and egress can be looked into during the course of the proceedings. Issue notice returnable in 4 weeks. As so and so appeared, accepted, so and so. Having regard to the fact that the 2 bighas of land mentioned in a notice are already acquired by the state long back, this court is not persuaded to pass any interim relief at this stage. The matter of ingress and egress from the public road to the petitioner's Pata land would be considered on the basis of the pleadings of the parties.
Order implement item number 8.
May I please, your lordship? Lordship, this IA has been filed for implementing a new part, respondent lordship. This is a contempt matter, lordship. Earlier, contempt now was transferred, lordship.
Who was transferred?
Lordship, Anurag Goel, lordship.
For that, have you brought the order to the notice of the new incumbent?
New incumbent lordship, Akash Deep lordship.
Have you brought the order to his notice? No.
No lordship, we have
And
not received.
first bring it to his notice. Then only he would come to know about this order. That is the procedure.
Lordship, as per our information, lordship, is the Akash Deep is
Wait a
new
statement.
statement, lordship. Lordship.
Better after bringing it to the notice of the new incumbent, get the acknowledgement, file the contempt.
Lordship, we have record it in paragraph number 7, lordship. It is our statement, lordship.
No, Mr.
NK Sharma, lordship.
M.K. Sharma.
NK.
File
NK.
N.K. Sharma, learned counsel for the petition, has submitted that the instant application is for implement of the new incumbent in the office of the Principal Secretary, Board and Autonomous Council, Cooperative. I am giving you liberty. First bring it to the notice, then file. He has, however, fairly submitted that the order dated 3/1/2022 allegedly not complied with, has not been brought to the notice of the new incumbent. In such view of the matter, he has submitted that the petitioner would like to withdraw this contempt petition and to file it afresh after bringing the order to the notice of the new incumbent. The prayer is allowed. The interlocutory application stands accordingly disposed.
Deeply obliged.
File.
Lordship.
Item number 9.
Yes, heard Mr. K. Mojumdar. Notice brought, Lordship, page 8, Lordship. Heard Mr. K. Mojumdar. Mr. A. Bhattacharyji, you are for?
Respondent number 1, my lord.
Okay. Learned counsel for the respondent, sole respondent.
So let's.
Full stop. The instant interlocutory application has been preferred, seeking implement of Joy Sivani, IAS Commissioner, Panchayat and Rural Development, Assam, Panjabari, Guwahati, 37, as a party respondent in the connected contempt petition C 28/2023. It has been averred that the sole respondent, sole respondent implemented earlier has since been transferred from the office of the Commissioner Panchayat and Rural Development Assam, and in his place, the proposed party respondent has joined as the Commissioner Panchayat and Rural Development Assam. As in view of such statements and averments made in the application, the interlocutory application is allowed to stop the office to implement the above party respondent, above and we will allowed in view of contempt case, in view of Mr. K. A. Mojumdar, learned counsel for the petitioner, and Mr. A. Bhattacharyji, learned counsel for the respondent of 1. In view of the order passed today in IAC number 3496/2023, the office to carry out necessary correction in the cost title. Amended cost title. No. The learned counsel for the petition shall submit the amended cost title in terms of the notification dated so and so before the registry. Office to registry. Issue notice to the newly implemented respondent who will be respondent number two in the array of respondents in the instant case. The notice is made returnable in 4 weeks. The petitioner shall take steps for service of notice by registered post with AD within 2 working days.
Much obliged.
Item number 10.
Respondent number 6 and 7, my lord. They are included as respondent number 6 and 7 in the repetition, my lord. That is why this IA has been filed.
This IA, okay. Heard Mr. B. Chetri. Learned counsel for the petitioner.
Yes.
N. Goswami, N. Bodoloi, standing counsel revenue 1. N. Goswami, junior government advocate Assam for the respondent number 3, 4, and 5. The instant interlocutory application has been prepared by the applicant. No, sorry, the applicant as the writ petitioner has prepared the connected writ petition. WPC number 4174/2023, seeking the relief of ex-gratia. Full stop. The instant interlocutory application has been prepared, seeking implement of the following authorities. 6 or 7 SPRO office agent as party respondents in the connected writ petition on the premise that those two authorities are necessary parties for adjudication of the issues raised in the connected writ petition. Full stop. The MS Bodoloi and Mr. Goswami, learned counsel appearing for the respondents aforementioned, have also endorsed the said submission of Mr. Chetri. As the above two authorities are found to be necessary parties for adjudication of the issues involved in the connected writ petition, the interlocutory application, the instant interlocutory application is allowed the office to carry out the necessary correction in the cost title in the connected writ petition on submission of amended cost title by the learned counsel for the petitioner before the registry in terms of the notification dated so and so. Full stop.
This item number 12 is also same, my lord. Only case number will be different.
And full stop. And list the writ petition. Writ petition. Because release the writ petition on Taiwan or Punya basis, Taiwan. We can issue notice.
They can have copies.
Heart WBC লিখি দিব Mr. B. Chetri, N. Bodoloi 1, N. Goswami 3, 4, and 5. In view of the order passed today in ISC number so and so, notice be issued to the newly implemented party respondent number 6 and 7. To stop, the petitioner shall take steps for service of notice or not. As Mr. Goswami has appeared and accepted notice on behalf of the newly implemented respondent number 6 and 7. No formal notice. Extra copies within 2 working days. The petitioner shall submit amended cost title in terms of the order dated today, passed in ISC number so and so, and the notification dated so and so before the registry within 2 days from today.
Unless the same order will be in item number 12, my lord. Only case number will
12.
be
Okay.
same order.
Thank you. Same.
Yes.
I took same.
Item number 11.
My lord, in this petition, I have a brief for impleading new incumbents, my lord.
New incumbent whom?
My lord.
Akashdeep.
Yes, your lordship.
And?
Akashdeep, Santa Baglari, and
Ah.
Sujit Basumatari, my lord.
Have you served them copies?
Yes, your lordship.
Copies, sir.
12/9/23, my lord.
পাৰিবনে গীতা? আকাশদ্বীপ, শান্তা পাগলাৰী, সুজিত বসুমতাৰী।
As respondent number 4, 5, and 6.
As respondent number
4, 5, and 6.
it has been submitted that by notice dated 12/9/2023,
23.
all the three, the order dated 30/2019 passed in the writ petition WPC number 4039/2019 has been brought to their notice. Main contempt is to same notice issued 4 weeks steps.
Obliged.
For admission, item number 13.
What is the case about?
My lord, I'm in the position of 8 ledgers of land in the Silabata town itself, my lord. And I'm in the position for
Why
since
is so
1986.
urgent to be taken up today?
My lord, only lordship may direct the respondents, my lord, to dispose of my representation, my lord.
Let it be on 4th of January. Tuesday or Thursday. I have to sign on the letter. So many motions I have to sign.
Lordship may fix up.
Fourth. You want disposal
Yes.
of representation.
Representation.
That will suffice.
Yes.
Then fourth. Okay. As agreed to by the Learned Council for the parties, this is the case on 4/1.
I'm sorry, my lord. Because now vacation is coming, my lord. That's why.
On 4/1, earliest I'm
Lordship
giving.
already been overloaded, my lord.
For orders, item number 14.
Some time for filing affidavit, my lord.
You not file.
No, my lord. After Bihu, my lord, in the meantime, I'll file, my lord.
Okay. MS P. Bormon. Learned Council for the petitioners is present. Mr. H.K. Das. Learned Standing Council has submitted that earnest endeavor will be made
Yes, ma'am.
to file counter affidavit on behalf of the
Got it.
respondent number
1, 1, 2, 3, 5. 1, 2, 3, and 5, my lord.
1, 2, 3, and 5 within 4 weeks' time.
No, Lordship. Long pending case, several occasion time has been granted.
No, otherwise, January 1st or 2nd of 4 weeks' time.
I would have done it, my lord, because subsequent instruction we received lately, my lord. So that's
The praise allowed. Release the case on 2nd February.
my lord.
Item number 16.
Lordship, in this
My lord.
case.
My lord, IS Civil Law 2597. I am for the applicant. This is an application with a prayer to make amendment in the main writ petition. My lord, actually at the time of filing of the writ petition, a prayer for granting of compensation was not included. But my lord, mass damage has been caused to my business. That is why mainly my lord, amendment with a prayer to include.
You are making Governor Reserve Bank of India a party.
Yes, my lord.
Chairman a party. What is your case about?
Actually, my lord,
What is your case about? Just trying to
Oh, yes, my lord. My SBI card was issued to myself without my consent.
Your?
I was issued SBI card.
Oh, SBI what card?
Credit card. Without
Not
my
debit.
my lord.
Not debit nor ATM.
No, my lord.
Who has issued that?
credit card.
Who has issued that?
SBI, respondent number 4, my lord.
Who is that?
SBI Card and Payment Services Limited.
So.
Without my
basic-
request.
Basic grievance is against that authority.
Yes, my lord.
Okay. Have you found out?
My CIBIL score.
No, no,
Yes,
1
my
minute.
lord.
Have you found out whether respondent number 4 is an instrumentality of the state, amenable to re-jurisdiction under Article 12 of the Constitution of India?
Yes, my lord, because they are
Find out.
doing public utility service, first of all. This
What
is
public utility? This is clearly business.
this is my lord.
You are customer or client for them?
Yes,
This is
my lord.
not.
They are
This
created
credit
by
card
State
is
Bank
not
of India.
public utility business,
My lord, they are
like electricity or water.
my lord, they
And
are
this is completely a private limited company, nothing to do with SBI.
no, my lord. SBI created is SBI hold more than 50% of share of SBI Cards and Payment Services Limited. And
We will examine this matter not today
My lord,
My lord.
I have
regarding amendment also.
My lord, I have also
The
filed,
maintainability of the writ petition itself is in doubt.
my lord, I have also filed a miscase for deletion of the respondent number 3 is a chairman of the, my lord.
It will be taken up on another date.
My lord.
Mr.
K. Dash.
LP Nath,
yes, my lord.
learned counsel for the petitioner. And Mr. K. Das,
Respondent number 3. your lord.
learned counsel for respondent number 3. Anybody else?
I am appearing for respondent number 5, S. Rava.
S. Rava for the respondent number 5 are present. Okay. As agreed to by the learned counsel for the parties, leaves the case on Tuesday date after Bihu.
Yes,
Dear.
Obliged, your lord.
We'll examine that amendment part, also deletion part.
my
My
lord.
lord,
But
my lord.
before that, we'll also go into the maintainability of the repetition.
My lord.
Item number 17.
Obliged, your lord.
Come prepared.
May I please, your lordship? My lord, in this case, my enrollment friend, he has filed an IA for impeachment, my lord. My lord, we have received the copy and we have sent it to the department for the instructions. My lord, can it come after the vacation?
You are seeking implement.
Yes, yes.
You would like to file objection.
There is a possibility that we may not also, but let it come on.
A date may be fixed, 10th of January,
Why you are so
because my dues, I have
sorry, Mr.
J. Bora.
J. Bora,
Yes.
learned counsel for a petition. R.J. Das, learned counsel for the applicant in ISC number 20. As agreed to by the learned counsel for the parties, leaves the case on 24.
Hello, I am for the respondent number 4 and 5.
Other things are crowded already, that is what. And it will be in the orders column, not be taken.
Item number 18.
Yes, what is this?
My lord, what happened actually? Earlier counsel he has left the brief and he has given a NOC and I have been engaged. After going through the brief, I find that writ petition has one writ petition file over another writ petition will file over that writ petition in IA. So there's so many.
This application is an application under Article 226.
Under 226.
For issuance in the nature of it in the nature of mandamus.
So this is what that type of thing is doing. That's
Yes.
why I want to withdraw and wait till you want to file a fresh.
Okay. Good. Want to file additional pleadings.
No, I want to withdraw this. I want to file with the addition to file with a prayer to file a fresh writ application in future.
Fresh petition.
Yes, please.
Okay, okay.
With
Both.
letter fresh. Yes.
So you want to withdraw IA as well as writ petition.
Both petition. I want
Okay.
to withdraw.
With your liberty. Okay. Third, Mr. S.
Withdraw.
Withdraw. 18. You have filed Ukalanama.
Yes, I have filed Wakalatama. I have filed Wakalatama. It is recorded.
Okay, okay. Ukalanama is here.
Requisition.
Okay. Learned counsel. Appearing for the writ petitioner and Mr.
A Dhanuka Lordship.
A. Dhanuka. Learned counsel for the sole respondent.
Sole respondent, bank.
Okay. Full stop. Mr. Dotto, learned counsel for the petition, has submitted that as there are some defects in the repetition, comma.
Mr. Mitra.
Huh?
Not Doctor, my lord. Doctor.
Sorry, Mitra. As there are some defects in the repetition filed by the earlier engaged counsel, comma, the same need to be cured. In such view of the matter, the writ petitioner wants to withdraw the writ petition with the liberty to file afresh. Full stop. Mr. Dhanuka, learned counsel appearing for the sole respondent, has no objection to the said prayer. Full stop. In view of the above submission made by Mr. Mitra, the writ petition stands dismissed on withdrawal, comma, with the liberty to file with the liberty as put for. In view of the order passed today in the connected writ petition WPC number 4875/2023, the instant interlocutory application stands accordingly disposed of.
Item number 19 and 20.
May I please, your lordship? Lordship, this repetition was earlier listed on 18/11/2023, whereby this honorable court observed that perusing the Lawajima order dated 7/11/2023, observed that if the petitioner wants to take fresh steps on the respondent number 8, 11, and 14, then an appropriate application is required to be filed. So we have filed this, lordship.
Mr.
My name is B.B. Kakoti.
B.B. Kakoti, learned counsel for the petitioner. And
M.A. Hussain for respondent number 6, my lord. In the first writ petition, my lord. And respondent number 5 in the second writ petition.
huh? How many petitions?
There are 2 writ petitions, my lord. In the first writ
This
petition.
I
In the item number 19,
3468
my lord.
is in WPC 3232.
232.
Item number 19,
Only make your submission confining to that only first.
my lord. Respondent number 6, my lord. In 19.
In the IA,
In the IA, my lord, it is
IA will be same.
my lord, same.
Okay, Mr. Goswami and Goswami, Junior Government Advocate Assam for the opposite party number 1, 2, 3, 5. And Mr.
A Burua for respondent number 15.
1 minute. Mr. M.A. Hussain,
Respondent number 6,
6. Mona Lisa Borapuka
my lord.
and Mr. A. Burua. Learned counsel for the respondent number
15.
15.
Okay.
You have made the government leader Gulagat as a party respondent. If any conducting council has to become a party in a writ petition, you will be implicated everywhere as a respondent. Is it correct? If Mr. Goswami, he appears in every writ petition listed before this court. If some other proceedings arise, whether he should be implicated as a party. Tell me, answer that question. Okay, the instant interlocutory application has been prepared seeking leave for taking steps for service of notice upon the respondent number 8, 11, and 14. Well, it was respondent number 8, respondent number 11, and 14. Included in the connected writ petition. It is in deference to the order passed on 18/11/2023 in WBC number 232/2020. Substituted manner, in the substituted manner by way of paper publication. Okay, so stop, আপনি লিখিব এই আগতে লবিটা আছে ৰুটেড থ্ৰু দ্য ৰেজিষ্ট্ৰি চাই ল'ব ৰেট অফ হিয়াৰিং দিব 9 to 16 to 16 to দিব ৰেট অফ হিয়াৰিং তাত নোটিছৰ ইণ্ডিকেট কৰি দিব লাগিব 16 to 2000 আৰু পেপাৰ পাব্লিকেশ্যন ইট বস্তু 1 monthৰ ভিতৰত আগত অৰ্ডাৰ ৰিপিটিশ্যন লিখিব একেটা নাম্বাৰ হেৰি কৰিব ইন ভিউ অফ দ্য অৰ্ডাৰ পাছ টুডে ইন IA C number 3468/2023 list the case on 16/2 because this date has to be notified in the paper.
Yes.
And this process takes time. He has to submit it before the registry, get it, then thereafter publish it. Thereafter again copies of the paper is to be submitted by way of a compliance affidavit. So 6 weeks. So it is cycle. IA is disposal.